Lord, I beg to mention item number 2 of today's Lordship. Let it come up any day next week, Lordship. Some difficulty.
What is the problem, Mr. Ganguly?
Lordship, Mr. S. Bora, he has some difficulty.
Mr. Bora will do the case or you will do the case?
Lordship, he will argue. Let it come any day next week, Lordship.
LCR has come 2020 matter, that is why.
Any day. Next Monday.
On the prayer of the council for the petitioner, Mr. A. Ganguly, place this matter on 5th of March.
I beg permission, item number 16, my lord. I'd like to withdraw as per instruction of my client, my lord. Item number 16. Bhushan,
You want to withdraw?
withdraw, my lord.
What's your good name?
J. Ahmed, my lord. You can liberty to file a fresh one.
Why do you want to withdraw?
Some technical problem is there. 16.
No, withdrawal is not an issue. You are paying for a liberty. Why do you want a liberty?
My lord, some documents are left off,
Which documents? We are only dealing with the records.
my lord.
We'll examine the records. Whatever is in the records, you cannot improve a case by introduction of new documents. If there is instructions to withdraw, that's a different matter. But you cannot, if you seek for a liberty, you have to have good reasons.
Right.
You're not being able to convince any reasons or cite any reasons. There's no scope of introduction of documents. Whose document? What document do you want to?
Sir, Gangura certificate, Panchayat certificate,
If those were before the tribunal, we'll have it in the records.
my lord.
Panchayat certificate was exhibit 12 before the Learned Tribunal.
And some of the voter list also.
Voter list, whatever was there, we'll examine. You cannot now incorporate any such document here in the writ petition to develop your case. Whatever was there before the tribunal, that only we'll look into, not beyond that. You think over. We are not giving you any liberty as such. You are not withdrawing. Or withdrawing.
Withdrawn.
Withdrawing.
Right.
Being angry with the impugned judgment and opinion dated 29/11/2023 passed by Learned Member Foreigners Tribunal, First Mongoldoi, Dorong, in FT case number 6922/2011, whereby she has been declared to be a foreigner under the Foreigners Act 1946. Foreigner oblique illegal migrant who had entered India, in Assam, illegally on or after 25/03/1971. The petitioner filed this writ petition on 17/02/2024. On instruction of the petitioner, paragraph 12. Mr. J. A. Ahmed, learned counsel, appearing for her. Praise for withdrawal of this writ petition. Seeking liberty as and when face cause of action arises. To which the counsel for the respondents, MS. A. Verma, standing counsel from the part. Comment. I have no objection. Parallel petitions been dismissed. On liberty. As and when face cause. Only when they get a case of record. Admission or 38, 39, but 15, 16, 13, 14, 15, 16 to 13, 14, no, 19, no, जी तक ना है number 1.
May I please your lordship? Lordship, my senior is mentioning one item in another code, lordship. He's here, lordship. Yes, ma'am.
No, order date was last photo, registered to the report at a fight. Detailed report on order date.
No, it's a Harvard City. Australian not too good. Register judicial. Register judicial.
Okay. Another one, my sister. तो मैं नहीं हूँ टाइमिंग तो item 8 Malibu date none appears date no representation of the petition.
At number 9 and 10.
May I plead your lordship? Your lordship, the engaged counsel for the matter, A.W. Aman has his legs at another court. Kindly adjourn the matter for the timing, your lordship.
9-10.
What's your good name?
S. Rahman, your lordship.
রোবা এটা উলাইলো রেকর্ড না থাকা
No, I don't.
না প্লিজ রেকর্ড আছে হ্যাঁ রিমোট আছে দুটো বা
By final order dated 17/05/2021. Learned Foreigners Tribunal Boxa, some NFP case number 43 oblique Boxa, oblique 2019. Declared the petitioner to be a foreigner.
The lordship, I'm reading for pass over your lordship.
We're not passing any adverse order. Oblique illegal mandate under the Foreigners Act 1946, who had illegally entered into the territory of India, Assam, on or after 25/0/1987. And specific petition by the petition filed on 22/12/2015. Call for the record. Not the Foreigners Act as a case. Essentially, it is matter for art. Same order. Separate. Cannot. Only. Number 12. FT case number 44. Boxer 2019. Winning order 17/05/2022. Only 10 to click. Petitioner carried is the own brother of the petitioner. The petitioner must be represented. Please this man.
Order pass. Order pass. I think you ask for the answer, even I can get him. You list them up.
6 January, 2nd to 3rd January. August 15. Yes, next. Gradually. We'll take it after some.
Yes, yes.
Lordship, item 11, we have the records. Sorry.
Very please, lordship. But that's right.
I see.
We record. We are having the matters where records needs to be called for first. Then we'll have the matters where we can go for a final consideration.
Lordship, the record has
Then
come,
of
lordship,
course,
then
lordship,
can it be lordship, another day, the admission item, lordship?
We'll see. We'll let it reach. There are matters above we will.
Lordship. Call later, no? Which one, lordship, no?
Person the
Elsa.
order for Miss Verma. Standing counsel from the court. Have placed the records in the original pertaining to PFT case number 247 of 2015. disposed of on 31/08/2023. The Learned Furnace Tribunal number 2 complete at Bhopal. Next,
12 also LCR is here, Lordship.
same order. Now, the file to pull from all of my-
It's ex parte matter, Lordship.
After some time. At ये लोगों I would
Application
without
number
LCR.
50 of Paksa 2019.
बाहर उनकी बाहर करते हैं ये দুটা বাহার তো না স্যার তুমি 15 નો কথা কৈছো বা 18 নিদিবা
ঠিক আছে।
এইটো আছে
Lordship is taking it another day, Lordship.
We'll see.
Lost.
Sometime. Item 13.
Lordship for this also LCR is the item 13 also. It would-
You have the records.
Yes, item 13 Lordship. 13 matters. Not 15, but like that.
Okay, give us the records. Next. What is it? 14.
Most of it.
We'll have it after some time.
Okay. 236 to deal with it.
May I please just, Lordship? Lordship, this is a contested matter. And the grandparents, the paternal grandparents,
Furnace Tribunal 4, Cambridge, Metro. Application number FT. Within bracket K, within bracket M, dash 4 bracket close. 1704 of
Notice it to
2007.
position.
Impugn opinion 29/11. Hard for it. Will this matter for? We'll have the LC of.
No, LCR it is called for the LCR.
Yes. 15. Report to call for.
Item 15.
Or the another.
That's the retool was from 22 to 22 LCR 9. 22 हुआ 26 हुआ 27 22 22 26 27 your item 22
yes,
ये तो क्या नाम है आपका
may I please, your Lordship, my seniors and legs in court number 1. And
15 तो क्या माता ना 15 तो क्या माता ना
and LCR has not been received.
What's your good name?
S sure. S sure.
no he has called for the
S
LCR from
sure.
the
SUR.
that's
It
it.
will not be taken up.
No done
No.
LCR has been called for or the past
ठीक है सर ये टिकट आपका सर्विस रिपोर्ट होती है ना सर लेटेस्ट का जो रिपोर्ट लेके आई थी कल आई थी तो ठीक जाती हुई तो अपन ने रिपोर्ट को चलो हमें
Item 22 to 31.
Order পিছত pass কৰিম।
Lordship, item 15 has not been taken up.
Item 15 মাতা নাই নেকি?
Vikram, 15 to Miss Kurisa.
No, we have taken up, we'll take it after some time. The council is not here. We'll pass the order after some time.
15 after some time. Hmm? Fifteen after 20, 20, 120, 22. Right. Yes, yes.
Take up another second.
Take up in the second half.
Keep going.
Second.
Questions आने की This is the ex party order of 2012 Lordship.
Second half.
This matter, there are continuous defaults.
Nobody is appearing also Lordship.
So second half will pass order. No point keeping this pending since 17.
39.
20,
This is,
29. In my house. It's on my house in Nagaland.
unnatural death. Second.
21 to 24. About
8, 9, 23.
23, 24.
পিছফালে আকৌ এটা জুলাইত আছে।
July.
25, 7. কিন্তু আগৰ page টো page টো।
25, 7 পাছত
Necessarily, 24 হ'ব লাগিছিলে।
এতিয়ালৈকেও মানে কৰা। এইটো কৰি যাবা।
ই আহিব পাৰে। এতিয়া ভবা নাই নেকি? Mr. Mahanta, please take your seat for a while.
Don't be confused. Then do it.
It will have better. First, second. No, no, what to window. It will have Rejoinder file karo.
Well, in this case, I was supposed to file the reply, but I have decided not to file, because the earlier order, there was a 24/8/2023. There was an order from the Honorable Court to produce the record. Well, the record may be, produced. The record will say everything, along in the post-mortem report. Affidavit that has come from the respondent number 12 also. Because the photographs and the other all circumstantial evidence, it is pointing towards, that is been killed. But their submission was that is a suicidal case. That is the things, that will be decided by the Honorable Court. Because all the police, this jail manual, they have all violated, not followed the all jail manual procedures. Nothing was there. So allegation against the entire jail administration.
Mr. Mohanta, there are two affidavits.
Yes, two affidavit.
One
That is,
is by 2, 4, 5, 6, and 7.
yes, my lord.
And against that, you have also not filed any
No.
rejoinder.
My lord, because the
And
another,
the other affidavit is by respondent number 12, who has
12.
been arrayed in personal capacity.
yes, my lord.
It's up to you. If you don't want to file a rejoinder, we can go ahead.
Then, my lord, one time may be given, because if ladies, staying in, Silsar, so that is the difficulties, my
Now,
lord.
that is the reason we are giving the option to you. If you
Okay,
wish to
ma'am.
file the affidavit,
Yes, my lord.
if you abandon, you can say that we can then go ahead. Because there is an affidavit by a person.
Well, one chance may be given, my lord, 2 weeks time.
That is what we are
Okay.
thinking. Because respondent number 12 is by official, not by official capacity.
Partial
He is
capacity.
by name.
Yes, my lord.
So his averments perhaps you need to rebut,
Yes,
or
my
at least make an attempt to rebut.
yes, my lord. But by this time, they have to produce a record also, my lord, because there is an order.
I don't think any advocate of
The
Nagaland.
Nagaland advocate is not available, my lord.
Yeah. No, 1 week it may not be possible. Take
2 weeks,
2
my lord.
weeks.
2 weeks, my lord.
You inform the learned government advocate regarding the matter. Perhaps they are.
I'll inform, my lord. I'll personally inform, my lord.
Or you can please do one thing. You can call her. We can ask her to produce the record.
Then, my lord.
Maybe after some time.
Okay, my lord, I'll try, my lord.
It will come. Pass in the-
Possibly.
complete record is in- In fact, record, Mr. Mohanta, we have just checked. There is already an order to have the complete record.
Yes, my lord.
Perhaps he may be in.
With the possession of that record also.
Please call her. We will.
Must.
Tomorrow. Item 40. This matter may be taken up after some time. Mr. DK sir may declare this matter. Item 41.
Is it 41? 41. Review. Ase আমার file. 42 ML.
Forty-two. Diesel cycle. Who's there on the other side? CGC?
Sir, came over here. He has also filed affidavit, Lordship.
No, this kind of matters can be perhaps disposed of. We have a look at the affidavit. If they have made a statement that they are not causing any, taking any
Harassment
coercive
to the-
action and there is no involvement.
Lordship. And moreover, perhaps, Lordship, there is no any such case is registered against the petitioner, Lordship. So there is no any harassment.
Then we can close this, I think. If there are certain materials on the basis of which some action is contemplated, then matter will be different. If there are no cases registered, then how do you?
Yes.
Moved out of Dibrugarh. It is nice. Career of 7th edition. Page 25.
May it please your Lordship. Please.
Who's for the other side?
Dr. Saraf is appearing, Lordship. He's on legs in court number 27.
This is come for the first time.
First time. Was the respondent number 1 and 2, they are on KVN.
So Doctor, what do you say?
Your Lordship, he may start. Dr. Saraf is on his way. No, Amit is better.
Well, perhaps, Manu, maybe Manu would like to take up the matter. Because your lordship is the impeachment petition. They are saying that they are affected by your lordship's order, which is not passed. And that's why they are coming for infringement.
It's my appeal, my lords. I would request my lord.
Which order?
I'm just pointing out, I'm not, you can.
My lords, it can come from the honorable bench, but my lords, such a suggestion from the other side.
My duty to point out, my lord,
Dr. Saraf is not saying that we have to recuse. He is only pointing out.
Yes.
but I'm only
Decision
pointing out.
I bow down. I bow down.
Decision will take. Let
I
us
bow-
see how what.
I bow
Where is that order?
Your lordship may see,
We don't remember anything of this kind.
my lord,
Age?
they were not annexed the order.
No, my lords, it's on record.
BC.
And who is the appellant? Who are you, Mr. Bhalla?
My lords, I had filed an application for impleadment in the main writ petition filed by my learned seniors clients, my lords,
Okay.
wherein the subject matter of dispute was only limited to a blacklisting order passed by BPCL. Now, my lords, what happens is that the entire tender process was subject matter of the state of Maharashtra. It was floated at Mumbai, and the works under the tender had to be executed in Maharashtra itself. The blacklisting order is also passed in Bombay. None of the respondents are within the territorial jurisdictions of this honorable court, but that's a separate issue. But why I am aggrieved is that had it been the petitioner's case in the main writ petition, that he will confine himself to the merits of the blacklisting order, which is of 8th of December, because I would have no difficulty. But in the garb of the writ petition, my lords, what is happening today is that the entire tender process has been stalled. Because of the orders passed by this honorable court, my lords, the entire tender process has been stalled. Because of the fact that, my lords, the writ petitioner was blacklisted according to the tender conditions, my lords, he is out of the tender process. And I am the second person, my lords, I would have sailed through. So any orders passed, my lords, I have no difficulty if your lordships.
The financial bids have been opened.
Please, my lords. The bids have been opened.
You are the second. Who's the first? Who is the first?
Well, the first is the writ petitioner. But because of the blacklisting order, my lords, he cannot participate in the tender process, your lordship's experience. There's a bar, my lords, in every tender if someone is blacklisted. And when you impugn the blacklisting.
No, if there was a bar, how was his financial bids opened and considered?
My lords, when the writ petitioner preferred its bid, my lords, before that, my lords, the tender process had started. And therefore, my lords, the BPCL took a stand that he cannot be looked into.
No,
And-
the opening of the financial bids is in pursuance to any court's order.
No, my lords.
Yes.
Yes. Okay, my lords, I stand corrected.
Okay.
21st.
We directed that you open.
Yes, 21st, my lords, the learned division bench of this honorable court passed that order.
No, we are asking, trying to understand your locus in getting
Yes.
yourself implemented.
Yes, my lords, what my locus is, your lordship's question is very pertinent, my lords. That's the moot question. My lords, the blacklisting order is of 8th of December 23. Now, if this honorable court, my lords, restricts the ambit of the writ petition only with limited to the blacklisting order, my lords, I have no difficulty in it. But what is being done by the writ petitioner is that he prefers an appeal, a departmental appeal against the order of blacklisting, suppresses that fact before your lordships in his writ petition. So, my lords, first ground is suppression. Once
No, we are on the locus.
yes, my lords, locus, I'm telling,
These points or which we are urging now.
yes,
Definitely maybe points are for consideration,
Correct.
but those will be urged by BPCL.
my lords,
And
I'm
we can
coming.
have
My
we can direct the single judge to expedite with the hearing
lords,
Tomorrow it is there, my lord.
no, my lords, what I'm saying is that will not,
Tomorrow.
tomorrow.
My lord.
my lords, that if I be,
Today, madam,
if-
we have mentioned, madam, for tomorrow, it was allowed, madam.
Today it was supposed to be listed, it is not listed, so they mentioned it, my lord.
let's kindly
Tomorrow.
kindly see the effect of the orders passed. If your lordships will kindly go through the orders with me for a moment, let's kindly see the effect of the order.
See, if he succeeds,
Yes,
you are out. If he doesn't succeed,
but
you are
then-
in. But you cannot say anything with a blacklisting order.
Lords, I'm not
which is
saying,
trying to challenge.
I am
It
not
will be
saying-
defended by the department. It's up.
lords,
up
may I
them.
make myself very clear?
A competitor, justifying or saying something against a blacklisting, that will be honored. Where
Lords,
do you get your?
may I
where is
make
your
myself-
locus?
with subject to your lordship's pleasure, lords, may I make myself very clear? As far as the list of the writ petitioner with BPCL is concerned with respect to the blacklisting order, my lords.
Mr. Bhala, we have understood your point.
Yes.
You are only concerned with the stoppage of the entire contract, the process. Now, if rightly or wrongly, there's an interim order. If the interim order goes, there is nothing to be decided because once you take over, whether his blacklisting is decided in his favor or against him, will not make any sense. We have balanced the equities and passed an order that till this matter is decided, the final allotment will not be done. If he fails in his petition before the learned single judge in the blacklisting, you sail through.
Well,
What is
may I-
the scope
may I-
of your arguing or we listening to you hearing you?
So, my lords, why I'm
Justifying
saying
the
so,
action of BPCL, they'll justify.
why I'm saying so is, my lords.
In fact, this may lead us to have something else as if you are in, there is something between you and BPCL. Why are you so?
My lords, I can make that suggestion for the other side also, my lords. Because my lords, I will not enter that domain.
BPCL is contesting. It's not a question of suggestion.
My lords,
You,
as far as BPCL is concerned, my lords, it's recorded in the impugned order that BPCL has no objection of me being impeded. And why so, my lords? Because the entire tender process has been stalled. The entire tender process, and not only of BPCL, but my lords, pan-India, my lords, the entire.
we have to come, ultimately it boils down to who is the necessary party, who is the proper party.
That's right, my lords.
Will your absence have any effect in a fair adjudication process?
If my
In a
lordship,
list which is essentially between a tenderer and the owner,
lords, if your lordships may
they are not
clarify,
agreed by your
my lords,
participation.
then may I make one prayer?
If
my lords?
anything has been said against you, anything, that this blacklisting is done only to favor you, you come, you
Well,
show us.
well,
That is
may I
not
make
the
a-
allegation.
Lords, may I make a suggestion? Lords, kindly see
And
the,
this is tomorrow, you see the proceedings tomorrow.
lords, but once if the writ petition is allowed, my lords, then my lords, I fail. My writ appeal
You
fails, my lords.
also fail.
No, lords, kindly see the effect of the order for a moment.
Our highest bidder who was blacklisting is.
But highest bidder, your lordships will see his conduct also, a writ petitioner. A writ petitioner coming to court has to come with clean hands, my lords.
Allah, that we are not saying your submissions, which are not, will not be considered. Those will be considered definitely. His conduct will be of paramount importance, whether
Yes,
it's
second
approach
point, my lords.
this court in
Well,
with clean hands. But
may-
those matters, that stage have not even reached. We have not even reached that stage.
Lords,
Those will be considered.
my lords, may I make a suggestion, my lords?
But who are you
Kind-
to make this at this stage?
Well, let's kindly see the effect of the order for a moment. Well, I beseech your lordships, kindly see the effect of the order. May I place those orders?
He has come before this court. We are considering his case.
Well, let's-
Again, we are repeating, rightly or wrongly, there isn't some interim protection to balance. Tomorrow, the writ petition is coming up for final disposal. What urgency have you got and why should we implead you?
Well, let's kindly see, my lords.
Perhaps we are not inclined.
Lordship may see the single judge order.
My lords, when I started, my lords, my lords, I made myself very clear.
No, I'm sure. No, single judge order. Your Lordship. My lord.
अरे यार, अलग इधर से कोई फर्क नहीं पड़ता. Kindly see what. Please, my lords.
Mr. Bhalla, infringement application, you know, we are absolutely liberal. Giving a hearing to a party will not adversely affect the interest of the parties to a list. But you have to make out
That's what.
at
Let's
least,
kindly allow me to place the
some
orders.
semblance of a right of being heard.
Let's kindly allow me to place the orders passed by this honorable court.
We have read the order.
Let's allow me to, my lords, just take the honorable bench through these orders, my lords. Because what is happening, my lords, kindly, if the writ
See,
petition,
it's an intra-court appeal.
that's right.
We have seen the reasonings assigned. In fact, the reasons assigned are very elaborate. Those elaborate order is not even necessary. The Honorable Single Judge has taken pains to write that even there is no order from BPCL declaring any rights in your favor till now.
My lords,
Had
may
it
I,
been something or that the blacklisting has been done or to give you, you are not connected at
my lords,
all.
may I
at
make
this
an
stage.
attempt? May I make an attempt to show that why those reasons
Why
are
attempt? We would have given you the whole day if we find any.
No, my lords, I bow down
We
to
are
that,
not-
my lords.
we
Your
are not
lordships,
finding anything.
I'm not saying that your lordships will not hear me, my lords. But my lords, kindly see.
Yeah, we are very open to a hearing,
Very well, my lords.
but only in given case,
From page 31 onwards in the impugned judgment, my lords, they're just 4-5 pages. I'll take those lordships through those pages, my lords, and then I'll make an attempt to satisfy your lordship as far as whether I am a party to the list or not. Kindly have page 31 for a moment. Page 31, the penultimate para on the page, para 24.
yes,
Lordship has that. For taking a decision in this matter, the brief facts of the case needs to be enumerated. The writ petitioner has put to challenge an order dated 8/12/2023, by which he has been blacklisted for a year by BPCL. Lords, may I just pause for a moment? The writ petition is limited to the validity of the blacklisting order. Nothing more, nothing less. In view of the blacklisting order, the writ petitioner cannot participate in supply contract works that has been advertised issued by PPCL. And therefore, my lords, being aggrieved, the writ petitioner approached this court, white writ, my lords, the present writ petition. And in the order dated 12th of December, passed by this court, it was stated that the prayer for an interim order would be considered on the next date, that is 5th of January. So, my lords, this order, which only says that the interim relief shall be considered on the next date, was impugned by the writ petitioner
In an appeal.
in an appeal.
Yes, that we know.
And then, my lords, the operative portion has been culled out in the impugned order itself. My lords, may I just show that order to you, Lord?
Yes.
Further, we find that the prayer for interim relief will be considered on 5/1/24. In that view of the matter, this writ appeal is disposed of, directing that the bids of the petitioner's firm will not be rejected on the basis of the order dated 8/12/23. Further, the petitioner's firm may also be permitted to submit fresh bids for other works, and the order dated 8/12/23 shall not come in the way of the petitioner's firm. However, this order shall be subject to the outcome of the decision of the learned single judge with regard to the interim order, which is to be considered on 5th of January. Then, my lords, your lordships passed this order on 5th of January.
Yes.
And, my lords, it says on the next page, at page 33, the first line,
Yes.
please, my lords. This court further makes it clear that so far as the works in which the petitioner has submitted its bids, which are the subject matter of the observation of the Honorable Division Bench, the authorities may go ahead with the tender process and finalize the same. But before allotting the work, leave is required from the court. So, my lord, your lordships have seen that the prayer in the main writ petition is with respect to the validity of the blacklisting order.
Correct.
Now, my lords, there is no prayer in the writ petition which says that the entire tender process should be stalled because I am blacklisted. There is no such prayer. I would have had no difficulty, my lords, if this honorable court would have restricted the dispute as far as the validity of the blacklisting order is concerned. But your lordships deemed it appropriate to go a step further. And the result of this observation or the direction passed by this honorable court that the entire tender process has been stalled. And your lordship's vast experience, my lords, a tender process can never be stalled. That's, my lords, I need not cite any judgment on that, my lords. It would be naivety on my part, my lords, to place any citation on that. And therefore, my lords, since I am L2 and he has no right to be considered, these directions are operating against me. And your lordships grants an opportunity to BPCL to go ahead and finalize the tender. But for allotment of work, my lords, your lordship's leave is to be taken. So, my lords, what is happening now is, this is, my lords, petroleum gas, my lords, cooking for cooking households. The entire process is in vain. Kindly see the effect of your lordship's order. Further, my lords, I'll read. The applicant being aggrieved with the impugned order dated 5/1/20.
So, we are again saying that you cannot hesitate against an order which you are not there. Your grievance before us in a division bench is against the order which has refused your entry.
That's right.
You can make your arguments on that. You have to make an argument that the interim order is bad. You don't have the locus.
No, I'm not saying.
But your submission is focused on that.
Why I'm making that submission, my lords?
And if you have already read out the chronology of events,
Yes.
the orders, interim orders, the initial orders were not to give any interim relief to the petitioner.
It has been given.
If you see, the interim
virtually the writ petition has been allowed.
interim order was not passed on the first day. There is an order of the DB to reconsider. Only after that, there is an interim order that you go ahead, but still, before you allot the work, you take leave of the court.
Now, my lords, the moot question which arises is,
Now, can you go to a question of the interim order by a stranger to a proceeding without getting himself inducted? And your induction has been rejected. saying that you
that's
don't
why,
have
my
the
lords,
right.
I'm in challenge, my lords.
So you have to focus your arguments on the rejection of
My lords,
your
I'm
entry.
reading the impugned judgment for that purpose.
Now, how is the interim order affecting those? Perhaps will not, may be connected, but those cannot be the focal point of your arguments.
But let's kindly see the reasoning given, my lord. I'm coming on the reasoning now.
We have seen the reasonings.
So it's
It is placed tomorrow for final disposal. At best, we can make a request that make an endeavor to final dispose of the matter.
Well, that will not solve my purpose, my lords. Here is a writ petitioner.
Now, you know what to do if it is decided
My lords,
in which you think you have a say. You can always file an appeal.
Look, that's-
Seek leave to file an appeal.
because that's,
But your
my lords, as far as my legal right is concerned to prefer 136 against this order, my lords, that remains.
not 136. You
Please.
can still file an writ appeal.
No, my lords, but then,
Against, if the order tomorrow, it goes in favor of the petitioner, you can still ask for a leave in a division bench.
my lords, then,
Grant me leave to file an appeal. I'm an affected party.
my lords, when your lordships will not agree with me, then the learned single judge will never grant me that leave, my lords.
No, not before the single judge.
Yeah.
If an order which is against you by the learned single judge,
That's what
final
I'm
order,
saying.
you can seek leave in a division
But
bench
it's
to
once-
put for appeal.
Once, my lords, my impleadment is rejected, my
No,
lords,
your
no,
rights have not even, we don't see any rights. Even, there's no semblance of any right.
my lords, kindly see the reasoning, my lords. Just two paragraphs, the reasoning which
And
has
the
been reported.
blacklisting, it's essentially a list between the petitioner.
My lords,
and the
I bow
corporation.
down, I bow down, that's why
It's
I'm,
up to the petitioner. You cannot justify, you cannot say anything. It's up to them.
my lords, that's why I'm saying, my lords, had the
I think
Had the-
I think we have
At
heard
the
it.
ambit of the writ petition being restricted to the blacklisting order, my lords, I would have no difficulty. I would have absolutely no difficulty. But what is happening, my lords, is under the garb of the writ petition, the ambit and scope of the writ petition has been enlarged. When you are not, please. my lord. That's- Yes, well, let's kindly see, as far as jurisdiction is concerned, my lord. Kindly see page 33, para 29 also for a moment. Well, no, my lords, that something will fall from that.
29.
29, my lords, at page 33. It says, the above being said, it is seen that the said tender number such and such, dated such and such, is in relation to the supply to be made in Maharashtra.
That is
Which-
exactly what is being pointed out to you. Jurisdiction issue would be perhaps a preliminary issue.
Please.
That whether the writ is maintainable at all.
Then, my
Here,
lords, may I make a request?
Yes.
May I make a request?
Yes.
Subject to your lordship's consideration. If, my lords, the aspect of jurisdiction, both territorial and maintainability of the writ petition, with respect to the departmental appeal being made available, can be considered as a preliminary objection, my lords?
No, it can be done if the prayer comes from BPCL that we had made a.
Because
such
they've
an
stated it on
objection.
affidavit.
Such an objection, it's not been decided.
Well,
Do you have any materials to show that this point will not
Yes.
be taken up?
No, my lords, they have taken this point.
Then,
B-
then,
BPC then your lordship may,
It's up
then-
to learned single judge. We
then-
cannot direct.
no, my
anything
lords,
like
I am
this.
saying, what I am saying is, my lords, to balance the equities,
It's-
all
it's
that
up-
I am saying is,
It is up to the owner to raise this issue, urge this issue, and once it is urged, there is no doubt on our part. to
all that I'm
say or
saying, my lords,
anything,
is- all that
is
I'm saying
considered.
is,
Well, first submission will advance only on territorial jurisdiction. And
my lords,
will-
the submission may be recorded.
Well,
That
according to
as
the
far,
question
no,
of-
no, listen, there has to be a balance of equities.
Mr. Bhalla, out of the record, we can assure you,
Yes.
Mr. Borthakur is a very tough customer.
My lords,
The
Yes.
first day,
Yeah.
luckily one of us was hearing Dr. Saraf.
Please, my lords.
It was objected to thin nail, and therefore there was no interim order on the first day. So I think you can just watch the proceedings and take a call accordingly.
No, my lords, kindly see the reasoning, my lords, because the learned single judge says that no jurisdiction. And then finally, my
Where is
lords,
that no jurisdiction?
please, my lords,
Where is it?
Just kindly see that's what I was showing, my lords. Para 29. Kindly see the effect of this observation. Well, it says the above being said, it is seen that the said tender is in relation to the supply to be made in Maharashtra, which is under the jurisdiction of the Bombay High Court. That's a serious finding, my lord.
Just show us from the affidavit of
Yes.
the BPCL where this jurisdictional point has been raised.
Please, my lord. Well, that
You can just
affidavit.
make a cursory mention.
Well, BPCL will mention it, will say that that objection has been taken, that affidavit is not on record. But Miloj, I'll just read it to your lordships in para.
Mr. Bhattakur,
Yes, sir.
definitely you are taking up the
Yes,
jurisdiction issue.
Yes, man, I have taken the issue, man.
And even for a moment, don't think that since they are sitting on the same side,
No, that's never.
tomorrow,
No, no.
some fireworks is going to happen
Can
between.
you show us the tender?
No.
Do you have a copy of the tender? Just if you do not have two copies, doesn't.
That's
give
never
us-
the Miloj. It's because of practice and procedure, Miloj, that the respondents sit on one side and.
I will only, without
Just give
disturbing,
us the tender.
without disturbing,
Dr. Sarab, perhaps not required.
without disturbing.
And you can say,
Well,
What-
what I'm
what do you
saying,
want to
the objection which they are saying again and again, the tender was for 2 years. Well, also, see,
no, see, those matters, please do not argue. You argue before the
no, that's
appropriate.
why I'm saying that you,
Appropriate bench,
we have
you
given
know,
reply
we are
also,
not even going into those aspects.
we have explained the reply, Milord, that.
Yes, Mr. Bhattakur, anything where in the affidavit you have taken jurisdiction?
Yes, yes, the reply specifically.
Mr. Bhattakur, which clause relates to jurisdiction? There has to be specific. I believe. And just cross from that point out that one.
No close by, in the court. Well, if you do division. I'm not dividing it. Like, if we offer, we have taken all, taken the territory jurisdiction.
Can you show us from the tender book?
That's it. Paragraph 3 of the affidavit.
It is there, Miloj. Secondly, Miloj,
So
in
the
their
last part-
affidavit.
Various point where, if I visit from Maharashtra somewhere, and that's only was people in Maharashtra, but we meeting.
Okay, give us.
My lord, I think. Making any objection, you also may say that the territorial jurisdiction issue will be heard first. Well, I have no objection for that. But any observation from this, your also, my lord, on the merit of the territorial.
We are not saying
Well, I'm
anything.
not requesting.
The territorial jurisdiction issue.
Now, listen to the order, we're going to
Supreme
pass,
Court judgments
no,
are
we are going to
Well,
pass a
Supreme
very
Court judgments are
innocuous.
there, the territorial jurisdiction issue has to be decided first. We will be arguing first, my lord, territorial jurisdiction, there is no issue.
That
at
is,
all.
that is otherwise also a procedure in
Well,
law.
that
that
is, we'll
The
decide.
preliminary issue on jurisdiction or
First of all-
territorial has to be taken up
Apart from
first.
that also, Miloj,
First,
may
I
I just.
have to satisfy the court that this court has the territorial jurisdiction, otherwise, we don't know how.
Yeah.
I can argue.
Read petition. Read petition.
I think, Rit, you have a next here.
Miloj, let us not be the next, because Miloj, it has not been served upon me.
From base, maybe, they will be tendered.
The Gujarat judgment.
I think next day, it was the case.
अरे भैया ये तो हम नहीं कर सकते आप ऐसे करो इसमें हम पार्टी
Well, if you look into one judgment of the division bench of the Gujarat High Court, my lord, on the blacklisting itself, on the territorial jurisdiction, if you also just want to look into it, my lord,
Nothing.
paragraph 16, my lord.
Which one? Oh, Gujarat High Court.
My lord, just only for the, my lord, that it's not so, my lord, that it was in respect to the blacklisting order.
No.
Third,
Plus, I just wanted to point out, Milot, just one order and the reasoning given by the learned single judge. Let's kindly have page 39 for a moment.
39.
39. Let's. This is your Lordship's order of 5th of January.
Yes.
That's the penultimate para, 2 lines. Pendency of this writ petition shall not be a bar to consider and dispose of the departmental appeal in accordance with law. Now, my lords, when the writ petition is filed, the pendency of the departmental appeal is suppressed. Let's kindly weigh, my lords, the equities. Your lordships time and again have held. And when the official respondent brings it to your lordship's notice, because the day the writ petition is filed, the very same day, my lords, the departmental appeal is preferred.
Supreme Court judgment.
Not brought to your lordship's notice. Whether in such circumstances, my lords, the writ petitioner has a right to pray for a discretionary relief from this honorable court. Not disclosed. So, my lords, there are two serious objections, one of jurisdiction and one of suppression. And the learned single judge in para 29, my lords, I showed prima facie that this honorable court has no territorial jurisdiction. And kindly, in light of that finding and your lordship's direction, kindly have now page 34, just 2 paragraphs in the impugned order. Because I could have understood, my lords, that the writ petitioner discloses on affidavit that yes, the appeal is pending, but because of reasons ABC, I'm preferring the writ petition. It's an alternative remedy which is efficacious in nature. Now, kindly have para 33 at page 34.
Paragraph?
33, my lords, at page 34.
Page 30.
34 minutes. And before proceeding, my lords, though, my lords, I understand my right is very, very limited, my lords, but the order of blacklisting is also on the ground of suppression. An incorrect statement, an incorrect certificate was filed, and therefore, my lords, the blacklisting order was there, my lords, but I'm just bringing it to your lordship's notice. Kindly have para 33. Your lordships, that now let's two things from your lordship's direction. That one, the tender process be finalized, but work should not be allotted without leave, my lords. That direction has not been complied with. Secondly, my lords, your lordship's 1st January order, my lords, grants BPCL to decide the departmental appeal. Because I don't know what is the fate of that departmental appeal. Because they could have proceeded with that. And once, if an order was passed against the writ petitioner, my lords, the writ petition would have become instructive, or he would have filed a subsequent writ petition. That's his domain. Now, kindly see at page 34, para 33.
See, on the last submission, Mr. Bhalla, that you do not know whether what has happened to the fate, what is the fate of the
Well,
department.
BPCL might be able to answer.
On that, see, if tomorrow the matter is decided on merits by this court, there's no question of deciding the appeal. There's no scope of deciding
The
the
writ
appeal.
petition itself is not maintainable. Your lordship's
No.
your lordship's judgments that when you have an
That-
alternative
that
remedy.
That maintainability hurdle, Mr. Dr. Saraf has to surpass first. Then the questions of merits should come. Even in fact, while coming to the merits, even the question of suppression would come as one of the preliminary grounds.
Please,
Those are matters, and if he is successful in overcoming those hurdles and the writ petition is decided in his favor, there is no question of the departmental appeal being considered or decided.
It has been withdrawn, my lord, the petitioner has withdrawn the departmental appeal. And
kindly see the
he says, no, let me see.
just kindly see the conduct of the writ.
My conduct, please kindly don't say about the conduct.
Because you file a writ petition,
Yes,
you
yes.
suppress. You
Yes.
suppress.
Who are you to say?
Because, my lord,
Who are you to say?
because my locus says that I am
My lord,
directly
lordship,
affected
Supreme-
by by the writ petitioner's conduct, my lords.
My lord, Supreme
You
Court judgment,
suppress that fact.
my lord, your lordship, see the one Supreme Court judgment, my lord.
Because
Directly-
there are
directly on
judgments
the
which I
issue.
can also place on record, my
Directly
lord.
on the issue, my lord, the first, in the head note first, my lord. First part of the head note, my lord.
Because there cannot be any judgment which says a writ petitioner, when suppresses facts, is entitled to discretionary. judgment.
There are no two views on this point.
Please, my lords, I'm only
Edition,
confined to that.
everything is very.
My lord, I am not
These are all
competent.
prerogative reads. Your conduct in approaching the court is of
Absolutely.
paramount importance.
Absolutely.
You have to be candid to the court, make a candid disclosure, should not suppress anything and reveal all relevant facts.
I bow down.
My lordship,
These are established.
The basic
And if
fundamentals
not
of
done that,
if your lordship-
corporate
they will
jurisdiction.
face the penalty.
my
before
lord,
single judge.
for my satisfaction, your lordship, the first paragraph, my lord, first head note itself, my lord. I will not trouble your lordship, my lord.
Yes.
My lord, the suppression of material facts, general rule of denial of relief applies only to the suppressed fact material one, that is one which would have the effect on the merits of case. Appellant filing writ petition not disclosing that he has already filed a civil suit for the same relief. High Court passing interim order on the writ petition, suit however withdrawn and not pending on the so-and-so was heard. In such circumstances where the writ petition was otherwise maintainable, felt that it would not be rejected on the ground of suppression of material fact, so-and-so. You have said that this is not a suppression. And you will of course see the paragraph. Paragraph is, my lord, paragraph 14. Although I'm not so competent to say, my lord, that there will no Supreme Court judgment at all. I'm not so competent, my lord. My learned friend can say that there will not be a single Supreme Court judgment. But
Dr. Saraf, all said and done, in this case, there was a suppression. You have taken remedial measures of withdrawing the suit.
no, my lord, here also, my lord, the Supreme Court, you lost me, just see. If
No,
it-
Supreme Court's case only, there was a suppression that the suit which was filed was suppressed from the writ court. And a remedial measure was taken to withdraw the suit, which is almost identical to the present situation.
I've also withdrawn.
Withdrawn.
So,
It's not mean that you have not suppressed.
well, my lord, let us say, they deal with the suppression, that this will not amount to suppression. You lost me, just see.
Page paragraph
My lord, you lost me, see, para 14,
1-4.
my lord.
Please read.
Para 14, the last 7 or 8 lines, my lord, 10 lines. But where in a parallel jurisdiction, has you also got him, my lord?
After Odisha case,
Para 14, last paragraph, my lord.
after Odisha case, Odisha.
My-
Gusa state of Odisha.
State of Bihar, my lord,
No,
SJ,
Understood. There is a reference to a Chandrabhutan Gusa in paragraph 14.
my lord.
Thereafter or before that?
My lord, just Odisha after that, my lord, 4-5 lines, my lord, after that.
Yes, but where?
Where in a parallel jurisdiction, the
Yes.
order is not a speaking one, or the matter has been disposed of in some other ground, the court has in suitable cases entertained the application to 32. Instead of dismissing the writ petition on the ground that the alternative remedy has been availed of, the court may call upon the party to elect whether it will proceed with the alternative remedy or with the application under Article 226. Therefore, the fact that the suit has already been filed by the appellant was not such a fact that suppression of which could have affected the final disposal of the writ petition. Thereafter, also similar. In the case, admittedly, the appellant has withdrawn the 2 weeks after the suit was been filed. In other words, the applicant selected to pursue the remedies only under Article 226. The pleadings were also complete before the High Court. No doubt the interim order which was passed by the obtained when the suit was pending, but by the time the writ petition was heard and the suit has already been withdrawn, a year later, although the appellate court would not on the High Court's reasoning take advantage of the interim order, it was not correct in rejecting the petition itself when the suit has admittedly been withdrawn, especially when the matter was ripe for hearing and all the facts necessary for determining this petition on merits were before court, and when the court was not in the view that the petition was otherwise not maintainable. As the issue of suppression was the only ground on which the High Court has rejected the appellant's plea for relief, we will ordinarily have to set aside the order of the High Court in view of the finding and remand it back the matter so and so.
May I just respond to this?
There is no question of whether
May I just
the
respond?
argument on the, the argument which are being advanced now are
Yes.
not for impleading. Lord, the impleadment application, in the impleadment application, he is paying for setting aside of your lordship's order.
Your Lordship may ignore that. I'm not pressing.
How it can be ignored?
I'm not
My lord,
pressing that.
No, not pressing, not
I'm
there.
not pressing that.
My lord, before the learned single judge also, it had been submitted that the order passed by the learned single judge in 512 is a nullity. It is void. My lord, I have never heard of.
It's okay. See, you are entitled to say anything. We are not entitled to say.
My lord, but at least so much
But
liberty
as far as
should, so
the
much liberty should not be granted, my lord, that anybody can say anything. My lord, in the
Doesn't
inter-court appeal also, we never say that the single judge order is nullity or void. We only say, my lord, the committed manifesto of law and something. We never say, my lord, is a nullity, void ab initio.
It's the effect
And
of
these arguments, my lord, these arguments of all these things can be advanced only after a party is impleaded as a party respondent. A party respondent without being impleaded, my lord, applicant. Well, on the merits or anything, well, the BPCL is the authority and they have filed all objections in the affidavit. We have given a reply. The matter was fixed for final hearing today. And since it has not come, well, BPCL made a mention before the court, and the matter is fixed up for tomorrow disposal. And so far as the interim order your lordship passed, my lord, your lordship just imagine, my lord, if your lordship would have stayed the blacklisting order, the consequence would have been there that the work would have been allotted to me. Where is number 2 and number 1, the work would have been automatically allotted to me. So,
we cannot grant the final relief without.
so
hearing.
my lord, your lordship,
We are balanced, tried to balance rather.
so my lord, the lordship, instead of staying the blacklisting order, gave some protection because in case, my lord, the tenders are rejected and my blacklisting order is set aside tomorrow.
Balance, tried to balance.
So my humble submission there, my lord, and the Supreme Court judgments, your lordship seen that in the learned single judge, my lord, had referred to all. The Supreme Court clearly said, my lord, the commercial interest of anybody, and if he was agreed, my lord, by the order passed by learned single judge by 5/1/2024, he could have taken a leave and file a writ appeal against the judgment. My lord, nobody can stop him from filing an appeal, but not filing the appeal against the learned single judge's order.
Okay, okay.
My lord, my lord.
Kamalaj, as far as the effect of this
Okay,
judgment
okay,
is concerned.
Okay, Mr. Bhala, we have heard.
Just two paragraphs on the impugned judgment.
Cannot be
Which
an amending process, we have heard you.
I just wanted to show the reasoning. My learned friend was
Which judgment?
not this judgment, but the reasoning given by the learned single judge. I was on that when my learned senior colleague was relying on this judgment, so I never interrupted at that point of time.
Yes.
Kindly have, my lords, page 34, para 33.
Yes, we have read this.
My lords, now, my lords, allow me to place why this reasoning might be incorrect according to my understanding. On considering the fact that the applicant is the lowest tenderer, as the writ petitioner has been blacklisted, the decision taken in the writ petition could affect the issue whether the applicant should be given the supply order. So, my lords, the prima facie view of the learned single judge is also that I might be affected. However, there is no certainty attached with the above issue. In the present case, there is nothing to show that the tender process has been finalized, though BPCL was given the liberty to finalize the same wide impugned interim order. There is nothing to show that the applicant has been selected by BPCL as successful tenderer or work supply order is to be given to the applicant. The tender can even be finalized with third or fourth highest bidder, and also such on the date the applicant, who is the second highest bidder, cannot be said to be a necessary party, as no legal or fundamental right of the applicant has been violated on the date. The applicant cannot be said to be an aggrieved person. The applicant can be said to be an aggrieved person only when he's selected by the authorities for allotment of the supply order. I pause for a moment. The prima facie finding is that I might be affected with these proceedings. After this finding, my lords, in para 33, because my application ought to have been allowed. And kindly see the converse situation now. That the learned single judge concludes that I would be having a right if I am aggrieved. Because the moment that happens, the writ petitioner will argue on the principle of fait accompli. So either your lordships, my lords, after just this penultimate paragraph, my lords, and I'll sum up my arguments, the para 34, my lords, the only issue as on date in the main case is challenge made by the writ petitioner to the blacklisting. Now the learned single judge concludes also that's the issue pending consideration. Now in facts and circumstances, when only the blacklisting order is under challenge, with no prayer in the entire writ petition to stall the entire tender process, which is concluded by the learned single judge also. So therefore, my lords, in facts and circumstances, I am an affected party and therefore ought to have been impleaded. This is my humble request to your lordships. And in the alternative, my lords, if your lordships deem it appropriate, if the maintainability issue can be gone into, and the dismissal of my writ appeal might not be an hindrance for further litigation, my lords, lordship may only clarify to that extent.
Is there any hindrance?
My lords, what will happen is, if your lordships decide today, being the final court as far as this honorable court is concerned.
Your attempt to enter into the list has been declined.
It has been declined.
Yes. But that will not affect any of your future rights.
If your lordship may clarify.
The honorable learned single judge has made it clear that since no rights have accrued upon you to be an aggrieved person, if any rights accrue, then you say that there's not a blacklisting interference.
Ultimately, my lord.
Let us,
yes,
in a given case, let us assume that the order blacklisting interfered with. You still think that interference may not be in accordance with law.
Right.
You can do
it. Ultimately, if your lordships will give me that.
And Dr. Taraf had rightly pointed out that even the interim order could have been a subject matter of an appeal before a DB. Take a leave and file an appeal.
I took my right to file an application for impleadment. So ultimately, if my lord will kindly just protect me to that extent, if your lordship will clarify that if aggrieved, my lords, I will be at remedy to exercise my rights in accordance with law. Nothing more than that, my lords, I'm requesting. In accordance with law, whatever my rights would be there, my lords, I'm only.
Whatever is according to law, we can pass orders. Whichever is not according to law, we cannot pass.
Very well.
Okay.
DPU.
Heard Sri A. Bhalla. Learned concept for the appellant. Also heard. We did not hear Mr. Bhattakur. Say something at least. Also heard Sri S. Bhattakur.
No, he's the best paid performer respondent, whereas he was not in the IA. In the single judge, he was not made a party. And in interpellation, he made a problem. How it can be done?
And we have also not heard Mr. S. Bhattakur. Okay. I also heard Sri S. Bhattakur, Learned Counsel, appearing for the Bharat Petroleum Corporation Limited, within bracket BPCL. Dr. A. Saraf, Learned Senior Counsel, assisted by Sri N. Dutta, appears for the respondent numbers
1 and 2.
1 and 2, within bracket writ petitioners. K. Google, Sri K. Google Learned CGC appears for the respondent number 3. The present intra-court appeal has been preferred against an order dated 20/2/2024, passed in IA Civil 285/2024 arising out of WPC 7421/2023. Full stop. Para. The aforesaid writ petition was filed by the present respondent numbers
1 and 2.
1 and 2
My lord.
as writ petitioners being aggrieved by an order of blacklisting. Full stop. The said writ petition was taken up for consideration by the learned single judge on 2023, wherein an observation was made that the interim order, that the prayer for interim order would be considered on the next returnable date, that is 5/1/2024. Full stop. Para. The aforesaid order dated 20/12/2023 was, however, the subject matter of a writ appeal preferred by the present writ petitioners, which was registered as WA 471 of 2023. Full stop. A division bench of this court by the order dated 21/3/2023 had disposed of the aforesaid appeal, the relevant observation of which is extracted herein below, paragraph 6 of the writ appeal judgment. Para. After the matter, thereafter the matter had come up for consideration before the learned single judge on the date fixed, that is 5/1/2024. Full stop. The operative part of the order passed on the same date is extracted herein below. Page 32, paragraph 26 of Para. The present appellant, who claims to be the second highest bidder, who claims to be the valid highest bidder, in view of the fact that though the financial bid of the writ petitioner was highest, since according to the appellant, the writ petitioner was not even eligible to participate, the bid of the appellant should be considered as the valid highest bidder. Full stop. Under those circumstances, an application under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure was filed for implement of the present appellant, as respondent number 7 in the writ petition was filed. Full stop. A prayer was also made for setting aside the interim order dated 5/1/2024. Full stop. Para. The learned single judge, while the order under appeal dated 22/2024 has, however, rejected the said application. Full stop. Being aggrieved, the present appeal has been preferred. Full stop. Para. Sri Bhalla, the learned counsel for the appellant, by referring to the relevant observations made by the division bench in its order dated 21/3/2023, has submitted that a perusal of the writ petition would reveal that there was no prayer for stalling the tender process, the present tender process. Full stop. He submits that even otherwise, a tender process can never be put to a halt as that would be against the interest of public. Full stop. The learned counsel has also submitted that the writ petition was filed by suppression of material facts in facts. Full stop. It is submitted that simultaneously a departmental appeal was filed, which was not revealed in the writ petition. Full stop. The learned counsel also strenuously contends that there is a preliminary issue on territorial jurisdiction, and therefore the writ petition itself is not maintainable. Full stop. He points out that even the order of blacklisting, which is the subject matter of the writ petition, would reveal that one of the reasons for blacklisting was suppression of material facts. Full stop. He accordingly submits that to have a fair adjudication, the appellant should be given a scope and opportunity to contest the writ petition, and his presence will not cause any prejudice to the parties to the lease and would only assist the court to come to a fair finding. Full stop. Sarah? Dr. A. Saraf, the senior counsel for the writ petitioner, respondent numbers 1 and 2, writ petitioners, however, seriously opposes the present appeal. Full stop. By referring to the impugned order dated 22/2024, he submits that while declining the prayer for impleadment, elaborate and adequate reasons and elaborate and cogent reasons have been cited by the learned single judge, and the present appeal being an intra-court appeal, the approach should be such. This court should be loath in interfering with such orders unless the same suffers from patent illegality or perversity. Full stop. As regards the issue of suppression of material facts, which has been raised on behalf of the appellant, Dr. Saraf submits that the appellant does not even have the locus to raise such arguments on merits, and in any case, the said issue has been adequately taken up by the owner BPCL, which would definitely be a part of the consideration by the learned single judge. Full stop. As regards the allegation of referring a departmental appeal simultaneously with the writ petition, Dr. Saraf, the learned senior counsel, submits that though it is a matter of fact that a departmental appeal was indeed referred, the same would not amount to suppression of material facts, as the same would not have any bearing on the adjudication process.
Department of
He has also
after filing of the petition.
he has also submitted that the appeal has in the meantime been withdrawn. Full stop. Reliance has also been placed on a decision of the Honorable Supreme Court reported in 2004, 7 SCC 166, named to Didipa, wherein a situation of identical nature, of similar nature, was there, as a suit was filed along with the writ petition. Full stop. The Honorable Supreme Court, however, had held that filing of a suit would not amount to suppression of material facts. Full stop. Para. On perusal of the materials on records and the order passed by the learned single judge dated 20/2/2024, we are of the opinion that the case of the present appellant was duly considered and the prayer was rejected after citing cogent and adequate reasons. Full stop. In paragraph 33 and 34 of the order, comma, the reasons assigned are cogent, plausible, and acceptable. And this appeal being an inter-court appeal, comma, we would be loath in interfering with such order. Full stop. We are also been informed that the writ petition itself is coming up for final consideration tomorrow. Full stop. We have also noticed that the issues of territorial jurisdiction is specifically taken up by the BPCL in its affidavit, more particularly in paragraph 3. Paragraph 3. Full stop. The affidavit has also taken up the point of suppression of material facts. Full stop. Para. We see no reasons as to why the learned single judge would not deal with those issues which, in our view, would form preliminary issues for before going into the merits of the challenge. Full stop. We are also of the opinion that if at all the present appeal is aggrieved by any orders finally passed by the learned single judge, comma, the appellant would not be precluded in challenging, in approaching the appropriate forum for redressal of its grievances. Full stop. We have also noticed that the interim order of this court was not the subject matter of any appeal. Full stop. However, the said fact would also not stand in the way of the present appellant in case it wishes to refer, in case it wishes to raise any, in case it is aggrieved by any orders that will be passed by the learned single judge. Full stop. We will modify this plan.
Well, because if I also make such observation, I would
No,
submit to-
with this.
if the should amount to giving liberty, so when the file appeal, that may be, but that is open to them.
That's, they can always, you know, the
No,
process.
we'll change this plan. We'll change it. We'll not cause prejudice either to him or to him.
Fine, that's only.
With the efforts and observations, comma, we are of the opinion that no interference is called for. And accordingly, the writ appeal is dismissed.
Deeply obliged.
I'm highly obliged, no? Deeply obliged.
I am for what? I am for?
I am for stay of the judgment.
In view of the final orders passed. In the writ appeal. In view of the final orders passed by which the writ appeal has been disposed of, comma, no orders are required to be passed in the IA, which accordingly stands disposed of. Caveat.
My caveat.
Dr. A. Sarak, senior counsel, assisted by Sri N.N. Datta for the caveat. Full stop. The caveat, which has been lodged in respect of an order that is passed by the learned single judge in WPC. Full stop. Para. The caveat will be heard in the event this court considers to pass any interim order. Pero, ¿qué habías dicho?
DQ. Right, last line to tick for him. Mr. Watercourt, take back your.
He possess the record, my
It's sketchy. Earlier, there was an order passed by court on 24th of August 2023.
Yes, Your Lordship, I do have the record, Your
You
Lordship.
have the records
Yes,
in
Your
original? You have the records?
Yes, Your Lordship.
You have the postmortem report?
I have the PM report as well as the action taken report, inquest report, magistral report, and then the compensation which was granted by NHRC.
Will you file? See, in fact, Mr. Mohanto had initially said that though he had prayed for time to file rejoinder, he may not file the rejoinder. We pointed out to him that there are two affidavits, one by the official respondent.
Yes, Your Lordship.
One is in an individual capacity by the respondent number 12. Then he said that further chance may be given of 2 weeks. In case he files, it is okay. Otherwise, we'll go ahead with the record.
Yes, my lord. And by this time, my lord, I may be the right to access to the record, my lord, so that I can go.
In presence of her.
What are the records? Are there any confidential matters?
Lordship, nothing as such. It is just the PM report.
PM
and then
report,
the
you can-
initial.
You can
PM
share
record,
it.
I
You can
also,
share with him.
PM record, my lord, I got, my lord.
Then
because-
what else? What else do you have?
The other, my lord, the
Inquest
inquest report
report,
and other.
magistral
These are not official. I think you already have, but still then you can have a look.
But Mr. P. Mahanta for the. Will appear for an.
You can always get it.
Damage. Rachel Advocate General, Nagaland. For the state response. None appeared for the response.
So Moibilake Ole Lagakan, though he's distinct by name, but he's also a government official. Last time Chibu appeared.
Mr. Mahanta. On the prayer of Mr. Mahanta. The petitioner is granted further to its time to file or reply to the affidavits filed by respond. Placed on. Do you have copy? Twelfth of March.
12, must,
You file your affidavit prior to that,
must.
if any.
Deeply obliged.
The next fixed, Ms. Casey shall place the relevant records in as directed earlier on 24/08/2020. Yes, we wanted to know whether the petitioner submitted his representation, that is for the registration. Get it, we'll take it up at 2 o'clock.
Lordship.
Mr. Sharma. Might have done it already.
Yes.
Timing item number 12. 12, 12, you are here. Good. It's what your particular here. Doctor, what is this? Well,
Second half probably হইলেন কি?
Hmm.
Second half আসলে
Asle.
লড়াই তো আসলে
Ambient, no? India ambient na number itu.
12, 12. Hmm.
Number 12.
Good, good.
May I please your lordship, item number
Yes, what you say?
my lord, council in item number 12, my lord, he's on his way, my lord. Sometime maybe done.
Who's there?
My lord, J. Abbas.
Mata সেগুলো হলো দাদা এই প্রশ্নটা হলো রেজিস্ট্রেশন
Yeah.
ইন্সপেক্টর
Here,
My lord. I'm sorry, Lordship, I was before another good Lordship.
no,
Impugnator page 25, Lordship.
no, come to that later. On the aspect of service of notice,
Yes, Lord.
what do you want to say?
Lordship, I have never been served, Lordship, the notice, and this, as per the order, Lordship, I have left the place, Lordship. But,
No, as per the order, you had refused to
no, Lordship, may kindly
accept the
speak.
notice for which there are two witnesses.
My lord.
One witness is the process server along with his report,
Yes,
and the other is the Gaunbura,
my lord.
in whose presence the notice was, since it was refused, it was affixed in a conspicuous place.
My lord.
That is the consistent version.
My lord. Lordship, may kindly see the page 25, second para, Lordship.
Oh.
The order of the Lordship learned.
See, basically, what you submitted is not correct.
No.
Notice was issued. The process server,
Yes,
police constable, along with the village headman, went to the house of the proceeding. She was there, but she refused to accept the notice. Then the concern that particular notice
my lord.
was affixed in presence, in a public place, in presence of the village headman.
Yeah.
But she refused to accept that notice. Thereafter, then the concerned process server, the constable,
My lord.
gave his evidence. He was called for by the tribunal, as well as the village headman who was present on that day
My lord.
when the proceeding refused. Very clear the statement of the village headman. I went with police in search of Ombia Bibi at Pokalagi and found the OP, but she refused to accept the notice. So the notice was fixed at a conspicuous place in my presence. That
Right.
is the statement of the village. So she was aware.
But
Even thereafter,
Yeah.
even thereafter, see the tribunal what it has
order,
done.
Lordship.
After recording the evidence
Right.
of the village. Another date was fixed for the OP. That was on 14/2020 for her appearance and written statement. But OP remained present, they absent. And accordingly, the order was passed.
My lord. Lordship, in fact, Lordship, in the impugn order,
Where is
Lordship,
the illegality? Just tell us where is the
Yes.
illegality?
Lordship, may kindly see the paragraph 2 of the impugn order, Lordship. Page 25, Lordship.
25.
Yes, my lord.
Please read.
Guzman, Lordship.
Hmm.
Page 25, Lordship. Second paragraph, Lordship. Mary, Lordship.
Yes.
May Lordship. Notice was issued to the opposite party. However, it seems that due to lack of any proof of citizenship and fearing adverse inference by the concerned authorities, the proceeding opposite party had left the village in order to intentionally avoid the service of notice on her. Finding no way out of the process server of the border police, pasted a copy of the notice on the conspicuous place as per the provisions of law in the presence of the village headman and local people and reported to this tribunal completing the service of notice. So here in this lordship order clearly says that I have left the village lordship.
Page 26, come to page 26, the first, second paragraph.
As per I have examined the process server of the concerned governor and heard the learned assistant government
See,
leader.
the records are before us.
My lord.
What you have just read may not be 100% correct that you have left. But the records and the materials on record would show that it was refused. The headman had also deposed that since you had refused, it was pasted in a conspicuous place.
My lord.
It is corroborated by the process server. How do you overcome the materials on record?
Lordship, even then, Lordship, if prosecution witness is examined, I have a right to cross-examine, Lordship. That aspect also may be seen, Lordship.
If you do not appear, how do you exercise your rights?
Because as per my humble submission that I am not.
And see, the tribunal did not close the matter on the same date. Tribunal still allowed one date.
My submission is that, Lordship, actually, I am a Lordship daily wage earner and I have to shift place to place, Lordship, for labor, Lordship. Lordship, since Lordship, I had not been given an opportunity to cross-examine also the prosecution, Lordship. So I may be given an opportunity, Lordship. Since Lordship, citizenship right is very important, right, Lordship.
So the question of cross-examination of prosecution will not even come. Duty is cast upon you entirely under section 9.
Yes, ma'am.
You have not discharged the duties. Now, only for the issue of whether the notice was served or not, the tribunal could have acted only on the basis of materials on record.
Right.
No, tribunal took the deposition of 2 witnesses, process server, village admin, because 5E says that if you did 5E of the 1964 orders, Three five.
3-5, Lord.
3-5. Oh, yes, 3-5.
3-5. If the proceeding is not found at the
If
address.
the proceeding or an available, 5E.
5E, Lordship.
Yes.
If the possessee or an available.
Proceeding, not processing, proceeding.
Oh, sorry, Lordship. If the proceedee or an available adult member of his or her family refuse to accept the notice, the possessor shall give a report to the foreigners tribunal to that regard, along with the name and address of the persons of locality who was present at the time of making such an effort to get the notice served, provided that such person is available and willing to be a witness to such service, and the possessor shall obtain the signature or thumb impression of such witness if he or she is present and willing to sign or put his thumb impression, as the case may be. But Lordship, in this case, Lordship, he has examined also, Lordship, as a witness, Lordship. This
it.
witness, Lordship.
Witness has been examined, this notice was served in my presence, refused. I was there.
This is the Lordship prosecution version, Lordship, and my Lord.
Prosecution version is not proving the case. Prosecution version is only for proving the element, the issue of service of notice, not on the merits of the case. Merits is upon you. You have to discharge your burden.
So even the Lordship, the order itself says that I have left the village, Lordship, and my submission is also that I may be somewhere for work purpose, Lordship, as a laborer, Lordship. So I may be get an opportunity, Lordship. And if the process is not found, Lordship. The imprint order, Lordship, and evidence contradicts itself, Lordship. My humble submission, Lordship. And if proceeding is not found, there is a provision to serve upon the adult member also, Lordship. That attempt has also not been done, Lordship.
Heard. Mr. J. Abbas, counsel for the petitioner. And Verma, peacefully for a listen. Four. Factory के area का 29 to 4. Support for pronouncement of the order. Question to the order is 10/20/24. The Governor Standing Council, the person place the relevant records of application of the right.
Placement.
One, two.
Or what? Or what?
Itu dah pun. Ini dia. Itu mati dia. Three. Ini tu. Bahan paling macam.
Mayor, please, Lordship. Lordship, talk about it for the time, Lordship.
Three, no? Three.
Three.
Three. Oh. Three months. Three months. It will not.
Who is the senior?
There.
Where is he? Online.
Sorry, Lordship. My senior is busy in another court.
It will be. Notice of protected.
You have the file?
Yes, Lordship.
Three to be open. Which one is the file actor? Everybody.
My lord, in this case, my lord, I have to go through the reports, my lord. The receipt culture has been just received, my lord. Go to the market different. Manipur Dukai Sami here, we appear yes, to photo coverage, I mean, substitution calculable later, I mean, to Shudra Mati, I've quit. I could lose your Shudra. My lord, here in this case, my lord, the same thing is in the notice. Charge is 2. But I want to go through the records, my lord. আইটেমটা তো পার হয়ে গেছে আইসে না নাই তো আইটেমটা তো পার হয়ে গেছে এই করতে আছে সি ধৰি এতিয়া তাৰ ক্লায়েণ্টক connect কৰিব একো ক্লায়েণ্টক এটা বজাত লগ কৰিব লাগিব
Originally. I think you should have preferred to read petition.
Well,
I think you should have preferred to read petition. The judgment is common, but there are individual challenge. One is the son of the other. Ideally, but that will consider.
well,
It becomes convenience then. Clubbing a judgment is okay, but should be, there are two initial proceedings. Judgment is the same. Now, writ petition should have been two.
yes, well, father and son, both the
Because all papers are different, notices are different.
notice are different, but judgment is common. And in the judgment, my lord, one thing, my lord, the one neighbor has elderly person, my lord, from neighbor is examined. Why this evidence cannot be considered, cannot be accepted? No reason has been given, my lord. That is another aspect. ওইগুলোর খবর নেই। কেসিপি অলরেডি Yes, that I will take No, 49 बाकी से और तो 48
Government platter.
Yes, Ms. Verma, Mr. Stigdar, go to the records. We'll take
My
it
lord.
at 2 o'clock.
My lord.
Ms. Verma, go to the record. So it to Stigdar. Fine, we'll take it up at 2. Fine. Yes, both of you have gone through the record. Okay.
My lord, I have gone through the records. My lord, they have also gone through the
Okay.
records. My lord. Here in this case, my lord, two cases are tied together, father and son.
That's on the prayer of the proceedee only.
Right.
What we have seen from the record, because there was a prayer to take up both the matters together.
Yes, my lord. And my lord, the ground, my lord, of challenge here is that one Samed Ali, elderly person of the locality, was examined. And there is no whisper at all about the evidence, my lord, both DW and DW.
There was a request on 24th of, as per the record,
My lord,
on 24th of
Can we locate there? Locate. The case actually.
August 2018,
my lord.
to fix this case, the present case, second one,
My lord, we have
Second
also not made any,
along with the other FT matter. So prayer was allowed.
well, in the writ petition, we have not made any amendment against that man. But here, my lord, the learned tribunal, lordship may kindly have a look at the judgment. The judgment has not whispered at all why the evidence of DW1, DW2 cannot be accepted. That is one of the major point, my lord. And tribunal also held that in third paragraph of the tribunal, proceedee submitted inadequate written statement which lack the relevant material facts.
Just a minute.
Zohur Ali is the father of Syed,
Yes, well,
and Hazara Bhanu is your
the mother.
Hazara Bhanu. But come to this page 36, though it is not even a certified copy. Let us just have a look, page 36,
Well,
or the vernacular at 37, wherever.
yes, my lord, there is
No,
there is difference.
Zohur Ali, no, not Ali.
Johar Ali,
Hassan M. Mota 66.
well,
Then Jahara Banu, this is Jafaruddin.
Zafaruddin. My lord,
Jahara is not the wife of Zohur.
my lord, there is a wrong my lord, recording.
Now,
In the
what is the name of your mother? Mother of Syed. According to you, what is the name of your mother?
Mother, my lord, Hazara Banu, as per the claim of duty, Hazara Banu is the mother.
Hazara?
Banu. Hazara Banu is the mother. My lord, against her name in 70 voter list, instead of Zohur Ali, it is Zohur Mal, it is shortly written Jofur. That is there, my lord.
No, Zohur Ali and Zafaruddin. It's not Zafar Ali, Zohur written as
My lord, in
Zafar.
65, my lord, Zohur, in 65, Zafaruddin. In 70, again, my lord, against Hazara Banu, it is Zohur. These are the mistakes, my lord, in the printing or enumeration, my lord.
And see the age difference, 66
Yes,
and 30.
age difference is there, my lord. That is there, my lord.
No, in a given case, there may be a age difference, but the name is totally different. Age is 36 years difference.
My lord, petitioner's mother is the second wife of his father, my lord. And after death of the first wife, his father, his mother was married there, maybe, my lord, age difference. That those things happen, my lord, amongst these people, my lord. That has been mentioned in paragraph 3 of the WS, my lord. Aimon-Nessa is the stepmother. My father has two wives, namely Hazara Banu, who is my mother. Hazara mother is my mother, and Aimon-Nessa is my stepmother. My father, namely Hazara Banu,
Stepmother had passed away.
my lord.
Stepmother was there or not?
Passed away, my lord.
When did she die?
My lord, that has not been, my lord, properly stated in the WS, but the father has two wives.
Well, 75.
Mother is 62. Mother is 62. 62 now I'm going to 65. Mr. Sikdar,
My lord.
you were emphasizing that in enumerating, giving names, there may be some
My lord.
discrepancies. But your stand has to be consistent. There cannot be discrepancy in your stand. Why am I telling you this? Because of the question which I am putting to you and soliciting your response. We are in page 36.
My lord.
Page 36. Have you got page 36?
Zohur Ali, father.
Father,
Mother,
mother is
Hazara
Hazara
Banu.
Banu. She is 30 years. And this is the voter list of which year?
65.
1965. And come to page 28. Your written statement. It starts at page 27.
My lord. Paragraph 3. No, under paragraph 3.
Kindly turn to the next page, page 28.
My lord. The name of the
You
name
have
of the
given
grandfather
everything, huh?
and grandmother of the
Okay,
opposite
okay.
party.
You can skip you have a few lines and you can start, I was born. I was born on 16/6/1960. About 12 lines.
Yes, my lord. I was born on 16/6/1960
At
at
village?
village Kawamari under Samuguri police station in the district of Nagaon.
Yes.
I have one elder brother, namely Kasim Ali, and one elder sister, namely Amirun Nessa.
My father.
My father was expert on 1980.
And my
Mother
mother.
expert on 1962. Also, my stepmother was expert on 1982.
See, 62, your mother has passed away. Her name is in the voter list of 65, as well as 70. Your stepmother passed away in 1982. In the voter list, her name is not there.
My lord, that is a wrong statement in the WS, my lord.
No, that is why we say that enumerator can be wrong. But this is what you have stated.
That is a wrong statement. My lord,
Where is the original? There may be some mistake in typing. Where is the original?
my lord, voter list.
No, the original written statement. Let us.
Lordship, in the record, my lord. I
To
think,
allay any kind of doubts,
My
let us
lord.
see the written statement.
my lord, Lordship may kindly have a look.
Yeah,
My lord,
62. It's not.
that is in the report. My
No, it's same. Same.
My lord, that is admittedly, my lord, it's a wrong statement, my lord. The advocates prepared casually, and these illiterate people, they cannot detect. But Lordship may kindly have a look at their oral evidence. That can be taken into consideration. Oral evidence, Lordship will find
60.
at page 64. These things have not been clarified.
Relief of Nampi.
Wonderful. My grandfather did not have any brothers.
Mahapurna. What is the name of your stepmother?
Stepmothers, Aimona, my lord, Aimona.
I'm one. My grandfather did not have any brothers.
Aimona Nessa.
Your mother is the second wife.
Petitioner's mother is second wife, my lord.
Second wife. Your second.
It's high that it is, but tonight, continues tonight. नाही father मध्ये projected करताना नाही they have different with it. Continue checking. Maybe 15 not explained. It is be represented. Nothing. याची discrepancy too large. Extract asset, extract integers cannot be certificate. By India. Itu exhibit mana? 240. You can decide with you. Discuss for 12. It's a leaky set. Was issued for the NRC purpose. Hmm. Continuously. Yeah. हमने शायद लिंक with this one. The factor will शायद भी
और क्षमा गुरु
नहीं
93 all of them all of them if you put in one careless is 20
Yes, Mr. Sigdar.
My lord.
Which is the link document between the petitioner Syed Ali with his father Johur Ali?
My lord, against the name of the petitioner, father's name is there all along in the voter list, my lord. My lord, in the voter list of 93, against the name of the petitioner's
But 93 voter
father,
list stands
Johur
in the
Ali.
name of one Sahad Ali,
Yes, my lord.
not against Syed Ali.
Then, my lord, 2005 also,
Hmm.
Syed Ali, father's name is Johur Ali,
Hmm.
in the voter list of 2005.
Hmm.
In 2011 also.
Hmm.
Then, my lord, 2016 voter list. So, in
All
the
are your
voter
father
list,
Johur Ali,
Johur Ali.
son of Johur Ali.
Yes, my lord. In the, my lord, notice and the records, my lord, it is there, it is there, my lord, record, my lord. The father's name of the PCD is the Johur Ali. So, prima facie, my lord, there may be taken a strong presumption that his father is Johur Ali. You are saying that my father's is Johur Ali. We have punished the voter list. My father's name is against my name in the voter list 2005 onwards. If we not considered in the voter list of 93, then my lord, one elderly person DW2. He has also claimed that he knows the father of the petitioner and he knows the petitioner since the date of birth, my lord. Paragraph in page 72. He's deposed, whatever I say, I shall be only true. Shall be only true. My name is Samed Ali. My age is 73 years. I am residing in Nilbagan. I was born at village Sonatop under Rupohi Hat, Samoguri constituency of Naga district. My father's name is late Immat Ali. Mother's name is Korbul Nessa. Today I have to adduce evidence in the foreigner's case against Said Ali and Azizul Haq. The opposite parties are my neighbor. I know Said Ali since his birth. Said Ali was born at Kawemari village, PS Rupohi. Father's name of Said Ali is late Johur Ali. Grandfather's name is late Hassan Ali. Johur Ali has no brothers. I do not know about the death of Johur Ali. I came to Nilbagan since 1981. Said Ali is staying in Nilbagan. In 1984, he came to Nilbagan from Kawemari. So far, my information, Johur Ali stayed few days in the village Koshukati. He stayed in the house of father-in-law. Mother's name of Said Ali is late Hazira Khatun. I do not know about the death of Hazira Khatun. Said Ali had one elder brother late Qasim Ali. I do not know about the death of Qasim Ali. So, well, very clear evidence and convincingly and impressively he has deposed. But there is no whisper about this witness. That is one of the serious lacuna in the impugned judgment. And the learned tribunal under paragraph 3 has stated that the proceedings submitted an inadequate written statement which lacks the relevant material facts. Well, admittedly, there is some lapses, some explanation is not there. But for that, whether a case can be, whether a negative can be taken this way, declaring a person a foreigner, when there is prima facie material that his father is a citizen of India having entered in the voter list of 1960, 75, 70. Well, all these are discarded without any reason. And
Have you any affidavit, evidence in affidavit of the DW2?
my lord, DW2, my lord, he being a my lord elderly person, I think he was only oral evidence was taken. Well, affidavit under oral evidence. Samed Ali, yes, my lord. Oral evidence is also there. Written evidence is also there. Page 68. Page 68.
Now, please read very carefully.
Which one, my lord? His evidence. DW2. Samed Ali, son of late Immat Ali, is it
Those are
about
not required. Okay, pair 2 onwards.
73 years of resident Nilbagan, both PS Muraja, district Ujai, do hereby
Read
solemnly.
pair 2 onwards.
The opposite parties of the instant case, my neighbors and known to them very well, and we are residing in the same village. But the opposite party are the son of Sohur Ali and late Hazara Banu and grandson of late Hassan Ali and Johura Khatun, who are the grandfather and forefather of the Azizul Haq. That the opposite party father and grandfather were Indian nationals by birth and permanently resided at village Koshokati, PS Rupohi, district Pujai. They have been residing permanently at the village till their death, and the opposite party, Said Ali, has shifted Koshokati to Nilbagan approximately on 1984, and also opposite party casting their vote regularly. My lord, nothing so adverse.
Please carry on.
That the opposite party's fathers and grandfathers of Azizul Haq name has been recorded in the NRC of 1951. White legacy data code number so and so in the district of Nagaon. That opposite party's parents and grandparents of Azizul Haq name has been recorded in the voter certified copy of 1965. White serial number so and so, house number so and so, part number so and so of Kawemari Moja Ranga Gada PS Samuguri in the district then Nagaon under 91 number Samuguri LSC. That opposite party's parents and grandparents of Azizul Haq name has been recorded in the voter certified copy of 1970 by serial number so and so, house number so and so, part number 50 at village Kawemari Moja Rangagada PS Samuguri in the district of then Nagaon under so and so. that opposite party's father and grandfather's of Azizul Haq name has been recorded in the voter certificate copy of 1975, serial number so and so, house number so and so, part number so and so, 44 number Samaguri LLC. That the opposite party Syed Ali name has been appeared along with other family members in the voter list of 1993, by serial number 293, house number 293, part number 61, under 19 number Jamuna Mukh LLC. The opposite party Syed Ali name has been appeared along with other family members in the voter certificate copy of 2005, by serial number so and so, under 19 number Jamuna Mukh LLC. The opposite party Syed Ali name has been appeared along with other family members in the voter certificate copy of 2011, by serial number 516, house number 136, part number 106, and under 19 number Jamuna Mukh LLC. That the opposite party Syed Ali name and his son, namely Azizul Haq, has been appeared along with
Others
others.
are not required.
My lord,
So in this particular evidence in affidavit of DW2,
my lord.
his address is Nilbagan, he is 73 years old. He has categorically stated that the petitioners, right, they are permanent resident of village Kosukhaiti and residing permanently at village, the same village.
No, my lord. Subsequently, he stated they shifted
No.
to Nilbagan. There has been
There are four of
yes, my lord.
till their date. Then
Kosukhaiti to Nilbagan.
Syed Ali has shifted from Kosukhaiti to Nilbagan in 1984, and opposite parties are casting their vote regularly. Their name figured in the NRC, that is different. Come to page number, which you have translated, page 72.
Vernacular is also there, my lord.
Whichever you read.
My lord. Whenever I say I shall be only,
Ah.
shall be only true.
So
My
this DW2, he said that he was born at village Sonatu under Rupunihar police station.
Sonatu. He born Sonatu.
He born.
My
You're
lord.
not saying about
DW2. DW2 born
Samir
Samaguri. My father's name is
He has said his name of his father and mother.
yes, my lord.
He came to court to adduce evidence on behalf of the petitioner, Buddha petitioner.
Yes, my lord.
Then you see, the opposite parties are my neighbor, right?
My lord.
I know Syed Ali since his birth. How can it be possible? This man took birth at village Sunatu, right?
My lord.
And they were at Kosukhaiti. Now he said, I know he's from birth, number one. Syed Ali was born at Kawemari village under Rupoi police station, which is not correct. Father's name of Syed Ali is late Zahur Ali and grandfather name is late Hassan Ali. Zahur Ali has no brothers. I do not know about the death of Zahur Ali. I came to Nilbagan since 1981. Syed Ali is staying in Nilbagan. In 1984, he came to Nilbagan from Kawemari.
My lord. Next line, my lord.
So
far,
far my information, that is what is
Yes.
information.
So far, my
Zahur
information.
Ali stayed few days in village.
Kosukhaiti.
Now, this particular DW2 were born and brought up at Sonatu, came to Kosukhaiti only in the year 1980-81, made this gentleman the petitioner in the year 1984 when he came to Nilbagan. How this man will know the petitioner since his birth? Right.
My lord.
And secondly, he said he came from Kawemari. He came from Kawemari. Right?
Well,
Now, your own written statement, page 28. Name, got it, page 28?
Yes, yes, my lord. Please.
Name of the grandfather and grandmother of the opposite party was late Hassan Ali and late Jahura Khatun. They had been living at village Kawoimari under Samuguri
Samuguri.
police station, not under Rupohiyar police station, has been said by DW2. In the district of Nagaon,
My lord,
till to their death, whatever you have
Till their
stated,
death.
till to their death, okay. My grandfather died approximately on 1955 and grandmother died in 1960. My father name is Zahur Ali, who was born at Kawoimari under Samuguri police station in the district of Nagaon till his death.
Till his death.
Till his death. My father has two wives, namely Hazara Banu, who is mother, and Aimun Nessa, in my stepmother. My mother, namely Hazara Banu, is also resident of village, namely Kawaimari, police station, Samuguri district, Nagaon. My father, along with his family, shifted from village Kawaimari under Samuguri police station in the district of Nagaon to Kosukhaiti under Rupohiyat police station approximately in 1977, searching for livelihood. As my father faced immense agricultural problem at village Kawaimari. I was born on such and such at village Kawaimari under Samuguli police station in the district of Nagaon. So how this DW2 is aware about your birth?
my lord.
Was he there at village
My lord,
Kawaimari?
this area is same, under same Samaguri police station. It's a Samaguri constituency. My lord, they may know one. I know many persons who are not my locality, by maybe of different area.
Mr. Sikdar, the position is very firm. He has vouched that he knows this Samadali since his birth. He doesn't say that he is related to the family of Samadali. He says, I'm a neighbor.
My lord.
Neighbor doesn't know when the wife of the neighbor passed away. He doesn't know when the wife of Samadali passed away.
Yes, my lord. There are some discrepancy. I
If you
also
are
agree.
relying on the
But
evidence of a
whether
particular-
the vital documents that my father is Zohar Ali, and that is also admitted by the state side in the inquiry report also, my father is Zohar Ali, and Zohar Ali is voter in 1965, 70, 75, and whether that evidence can be, my lord, can be this way thrown in,
No,
whether these are these discrepancies of the statement
Mr.
in the
Sikdar,
WS, my lord,
Mr.
prepared
Sikdar,
by lawyer, my lord.
Mr. Sikdar, let us come and let us go to the forget the versions of the lawyer. We have noted the discrepancy in the 1965 voters list. Zohar Ali, he is 66 years. Then Jahara Banu, wife of Zafaruddin. You say Zohar has been referred as Zafaruddin, the same voters list. Not possible, not acceptable, but still then let us assume. Page 36.
Well,
Zohar Ali, then Hazara Banu, wife of Zafaruddin. Same voters is not possible. Other voter list, there may be some discrepancy. But still then let us overlook this. Okay. The age gap is there. That is also raises some doubt. Then we come to the second part. You say in your written statement, father had two wives. One is
Aimun Nessa.
Aimun Nessa. And the second is your mother of Syed, Hazara Banu. Aimun Nessa, her name is not there in 1965 voters list.
My lord.
Why?
My lord. Yes, my lord. There is one statement in the page 28. My lord. My mother was expired in 1962. Lord, she was taken up.
We are not.
My lord, perhaps, my lord, the first, my lord, the first wife of his father expired in 1962.
No,
And therefore, my
no,
lord.
he has
So,
clarified.
my lord, all these, my lord,
No, no. First let us explore all the what has happened. he has clarified there is a stepmother.
my lord.
Specifically, stepmother is Aimon, his mother is Hazera, and looking at the age of his mother, it appears his mother is second wife, no problem. Hazera died in 1962 at page 28, you have stated in your written statement. Her voter list is in 65 as well as 1972, twice. Doesn't end there. You come to your first voter list. Your first voter list is of the year 1993, which is at page 42.
My name is written here as Sahad Ali.
Let us assume it is you. Syed has been written as Sahad, no problem. Age 42. 42.
Yes.
The next
My
question,
name is also.
you know the next question. Where are you all these days till you reach 42? From 21 to 42, where were you?
My lord, that has not been, that we admit, my lord.
Come to the, let us again on another question. 42, see your house number. 1993 voters list. We are on the same address. We are not going to the earlier house numbers. This is 293. Page 42. Come to 44. House number
136.
136. Come to page 46. House number 29. Then again at 48, 136.
My lord. My considered view is that this type of variation is, my lord, always going on, my lord. If you look the voter list of the village people, my lord, you'll find this type of variation. House number is not a factor. This is absolutely wrong.
Your Honorable Supreme Court in one of the decisions, perhaps you have cited, had taken into some of the given case where name changes, where Kafatullah was written as Kamatullah, F changed to M, and then to grandfather.
Well,
These are matters which can be overlooked. But here in every matter,
my
there is
lord,
a
my lord, the house number variation, my lord. The people are residing here, one village, one people, one house,
What about
another
one?
village.
Okay.
After few years, some
Okay,
people
okay.
coming in
I
between
am
these
putting
two.
the next question. What about the part?
My lord.
Part also changes.
Yes, my lord. Part also changes, my lord. That may be possible, my lord.
Then again, village will change. Possible.
My lord, these are
Why
the,
doesn't the
my lord,
why doesn't the country
my lord,
change?
whatever
Change
view
the
lordship is
country,
taken,
otherwise-
my lord, my submission is that, my short submission is that this discrepancy cannot be fatal to declare a person as a foreigner. My lord. Father is a citizen. It is the record of the respondent side, that state side, that my father is Zohar Ali.
That is the
That
exact-
voter list-
that is the link. That is the question. Father, there is no doubt on not your father.
My
You
lord.
just need to establish a link
My
which is
lord.
acceptable, cogent,
My
and reliable
father's-
with your father.
My father's name is against my name, my lord, in the voter list, my lord. He has passed long. What we can do, my lord? And some elderly person has come forward and says that yes,
Elderly
it is one of
person is not at all reliable.
my lord,
Contradiction.
my lord.
He is from a different village. He is not related to you. He
My lord,
doesn't know when
no-
your mother passed
My lord,
away. He
now-
doesn't know when your elder brother passed
My
away.
lord, now they are staying, my lord, in the same village. They are neighbors. My lord. That is the position.
Not now. He knows you from your birth. Not now.
My lord knows.
He knows
Even
you from
even
your
if
birth.
born in different village, he may be known, my lord. That is not impossible.
Then somebody passes
That-
away in the family, he doesn't know. He
My lord.
remembers selective things.
My lord.
This is selective.
It is not quite impossible that a person of different village cannot know the another person's.
No, Mr.
It
Sikdar,
cannot
this
be
is- this is
totally rolled
possible.
out, my lord.
This is possible. It is possible that it is possible for a person of this village to know a person of another village
Another village.
since his birth. But if he knows a person from his birth, it is also expected that he know somebody had passed away. And when questions is put to him, I may not know when he passed away, which year, but I know he has passed away.
But nothing has been questioned to this man, my lord.
Yes, there's been question.
My lord, nothing has been questioned, my lord.
I do not know about the death of Hazira Khatun. Syed Ali is one of her elder brother, Qasim Ali. I do not know about death of Qasim Ali. I do not know the wife of Syed. The person whom you know from your birth, you don't know his wife.
My lord, the question ought to have been, my lord, how we can know that this man from the date of birth? That ought to have been the question.
Why?
That question has not
Why?
been put, my lord.
Why should that question come? You know, DW
Right.
doesn't know the wife of your wife. He knows you from your birth. He knows everything.
No, my lord. He simply
just
knows
say-
that his father is so and so. He
Just
he
explain the
birth
last,
on in
just
so and so
explain-
village, my
just
lord.
explain the
My lord.
last line. I do not know the name of the wife of Syed. He knows that you have 6 sons and daughters.
Yes, the other family members are. He has the idea about the
May
family,
not,
my
may
lord.
not know the names of the children, but wife's name.
He stayed in this house of father-in-law. Mother's name is Syed Ali. Is late Hazira Khatun. I do not know about the death of Hazira Khatun. Syed Ali had one elder brother, Qasim Ali. I do not know about the death of Qasim Ali. One sister named late Amirun. I do not know the name of wife of Sahed. He has 6 sons and daughters.
Mere name appearing in the
Mirun. The more we are trying to help you,
My
the
lord.
more you are we have to be against you.
My lord, our luck is bad, my lord. Master, perhaps. My lord. My lord, before lordship come to conclusion, my lord, my short submission, my lord. My lord, this type of mistake, if lordship taking up, my lord, everybody can be declared foreigners, my lord. That is the position we are observing, my lord. My submission is that the prime evidence which are considerable, which can be taken into consideration, my lord, and that should be taken up, my lord. And the illegality and irregularity on the, my lord, the other side, my lord, that should also be looked into. My lord, here in this case, my lord, the tribunal has not discussed at all about the acceptability of,
DW2.
yes, sir. DW1, DW both, my lord. Nothing has been discussed, my lord. One thing, that is one part, my lord. And it is their own record that I am the son of Zohur Ali. I have produced some brutal list about my, I am to establish linkage with my father, not anyone. There may be some mistake in the mother's name. That should be ignored, my lord, in the light of the Sirajul Haq case and the judgment of Hyder Ali case also. Hyder Ali case, my lord, in paragraph 42, paragraph 3 has
Just a minute.
deposed, my lord.
Acceptable বলি একটু।
Yes, madam.
Yes, lordship.
Towards the last part of the argument, he has also hinted upon your failure. So how do you justify? You have not discussed DW2, he says.
Yes, lordship. Lordship, I'll start from the beginning first.
You have to start from the beginning. Can you start from the end? Is there any other way of starting?
Lordship, the petitioner has not been able to prove his linkage with his father in any of the documents which he has exhibited before the tribunal, lordship. And secondly, lordship,
No linkage with father proved.
no linkage, lordship, because all the voters list have discrepancies. Discrepancy in age here and there may be acceptable, but his discrepancies all consistent discrepancies in the date, year, lordship, and the materials and which with the documents and his
The voters
submissions.
list are consistently inconsistent.
Yes, Lord. In all the voters list, he has submitted before this court 65, 70 and 75, the projected father and mother lordship. Those, all these three different voters lists have a number of discrepancies which he has not been able to.
Show this thing will not do.
Lordship, I'm coming to page 24, Lordship.
2-4.
First is of 65, Lordship. Voters list of 65 is
Page
page 36.
36, okay.
Lordship will notice in the voters list of 1965, the house number is same. Whereas in the others voters list, it has changed here in house number 77.
Hmm.
There are other people relating to the family or maybe nearby people, Lordship. 277 and 278. He is referring to 277 as as his projected father.
Hmm.
And age is 66, Lordship. And mother is Hajara Banu, wife of Jafaruddin. This is the first discrepancy in the voters list. And the village is Kawai Mari here.
What is the discrepancy?
I'll take Lordship to the voters list of 1993 later on.
No,
This
this is the
first-
point where discrepancy will be there, that means.
Yes, Lordship.
Okay.
Then the second voters list is of house number 75, 1970 voters list,
Page
page 38,
3.
village Kawai Mari. House number is 75. And the same names, if Lordship notices, Aftab Ali is there. The second name, which was in 65, that is missing. Jahur Ali, the projected father, and the mother's names are there. And the age of the projected father is 71, and the projected mother is 35. Then there are other two names which are there, not there in the first voters list. Lordship will come to 75 then. Page 75, house number is 75.
Page 75. Voter list of
Voters list
75.
of 1975,
Just-
page 40.
Just a minute, just go slow, please. Page 7, voter list of 75, page 40.
Page 40, Lordship.
Yes.
This is of village Kawai Mari. And
No, no, village, yes, Kawai
Kawai Mari, Lordship. House number is 75. The name of father, projected father, is at 543 serial. And here, Lordship, if Lordship sees in the 70s voters list, Aftab Ali is there, Atab Ali. Here it becomes Akhtar Ali. And but the father's name is same. So the projected father, Jahur Ali's name is there, but the mother's name is missing in this voters list. She is not, her name is not there. Hazira Bhanu is not in this name at all.
Hazara Bhanu passed away.
She passed away, but even when the father passed away in one of the later voters list, Jahur Ali's name again reappears.
No, father passed away later, 82, I think.
82, but his name I have just seen in one of the later 82, 2011 Lordship.
Page,
Page 46, no, not that one, Lordship, there was one more. I'll just come. That is in 16. 1 minute. What's that?
I don't think it's there.
Thakur, please name available license Lordship will just give me a moment. 1980. Exhibit Lordship in Exhibit 8, Lordship 7 in Exhibit 8. Lordship has the
Page. Page.
records, Lordship. 8 to 2011 में के
2016.
2016 some 2016 no.
Or 2011.
Hmm. I saw it somewhere, Lordship. Anyways, in 2016, the father's name comes as not late, but Syed Ali, Jahur Ali. Page 48, Lordship.
Yeah. Without late.
Without late. So, after 1975, the first time
After
the
93,
uh,
from 2005 onwards, it was shown as without late.
without name. No, the name is there, Jahur Ali is there, but without late is not there in any of the
2005, 2011. It is
yes. And in 1993, the petitioner's name appears for the first time at the age of 42
That,
years.
not writing late, we may ignore because none of the voter list have indicates any late before the name of the mother, father.
They don't
In
have-
the earlier, all the voters list, none from 65 onward.
So we can,
That part
can
will
leave
not,
it,
we will not,
in 1993, when the petitioner's name appears, he's
Page?
he's page 42, Lordship, 1993 voters list.
Yes. As Sahad Ali.
Sahad Ali.
Jahur Ali. and
Yes,
Salima Khatun.
Salima Khatun,
Wife of Sahad.
wife of Saad, but
It
he
changes
Syed,
in 2005. It
and the
becomes Syed Ali.
and the petitioner is Syed Ali, but here the name is Sahad. And if his name appears for the first time in 1993 at the age of 42 years, he has to first show his continuous stay in the territory of Assam, Lordship. And Lordship will again come to page 44, voters list of 2005. Here, everything is in order. The name is according to what the petitioner calls himself, Syed Ali, son of Jahur Ali, Salema Khatun, and wife of Syed Ali, Sulman Ali, Syed Ali. And the next voters list, if Lordship comes to 2011,
What is it? Huh? There are few there are politics. No, but GPA there are person. There are person. There. No. 64. DW1. Member. Oh, GPA no. Review.
what I would like to point out is, I think when the petitioner's name appears with his wife, he is very mindful of having his son's name who just turned 90. That also reflects in the voters list. 2005, and then 2015, the whole family's name appears right up to his daughter at page 48.
Yeah.
My submission would be that he has come to India post 1971 and only from 2005 his papers are in order. At 2005, his own name and his family's name, he has been able to get his documents correct only from the year 2005. Lordship. Prior to that, all the documents the petitioner has exhibited are all bits and pieces for the sake of convenience and for the sake of just showing that he has been in the state for a long time.
Let us read his cross-examination at page 64.
64, Lordship. Lordship, I'll read the English translated one. My name is Syed Ali. My age is 58 years. My father's name is late Jahur Ali. My mother's name is late Hazira Banu. My grandfather's name is late Hassan Ali. My grandmother's name is late Pura Khatun. I do not know about the birth of my grandfather. Died at Kawai Mari. I do not know the year. My grandfather did not have any brother. I do not know about the birth of my grandmother, father. In the year 1952, Jahur Ali died Kawai Mari. I do not know the name of paternal grandparents. My father did not have any siblings. My mother died when I was 2 years old. My mother died at Kawai Mari, post office, police station, Rupohi.
My mother died when he was
2 years old.
2 years old. That means he was born in
He was only 65. If according to this affidavit we go, my age is 58 years, then he should have been born in 65. And the situation is of 20, so now he should be 60 years of age.
No, in the written statement, he says that the mother had died in 1962. He was born in 1960. Yes.
And but here it is my age is 58 years.
58 is, that is in the year 2020, I think.
If it's born in
2020.
20. And my mother died at Kawai Mari, police station, Rupohi. My elder brother late Kasim Ali. I do not know about the death of Kasim Ali. He died in Dimapur. My sister.
What was it? I do not know about the death of.
My
That means what
about
is it?
the death of Kasim Ali.
The cause of death, perhaps.
I do not know about the death of.
No, it cannot be because he said he died in Dimapur.
Yes.
He knows definitely. Cause of death.
মৃত্যুর বিষয়ে আমি না
Mitra because cause of death. Cause of death. Wrong translation. Mr. Singh.
মৃত্যুর বিষয়ে
My sister.
Your case is otherwise where you are making it worse by wrong translation.
My sister's name is Amira Nesa. My sister's name is Amira Nesa is staying at Neel Bagan since 1984. I did not go to school. Now I am selling vegetable. I have married Salima Khatun, daughter of late Baharuddin and late Amina Khatun of Neel Bagan in the year 1984. I have 6 sons and daughter, namely so-and-so. A foreigner case is also running against my son Aijul Ali. I have submitted the following documents before the court. NRC details in the name of father. Voter list of 1965 where my parents' names are available. Atab Ali. Atab Ali, Ojan, Atab Bhanu are different persons. Lordship, may kindly come to voters list of 1965. It is his state, it is in his query, Lordship. He says these are all 3 different persons. Voters list of 1970. He has not mentioned about
Exhibit.
his parents, your Lordship.
1965 মোৰ মা দেউতাৰ নাম আছে আটব আলী ৱাজান আৰু
Are different persons, Lordship.
আনু বেলেগ মানুহ
Different people.
1970 চনৰ তালিকাত
মানুহ নহয়
No,
সুৰুজ আলী আটব আলী সুৰুজ আলী আৰু মহম্মদ আলী বেলেগ মানুহ একেলগে আছে ঘৰৰ নহয় নাজানো আৰু 1965 চনত তালিকাত আৰু এটা নাম আছে আখতাৰ সুৰজ আলী মহম্মদ আলী
আৰু কিমান পাৰিলে
yes next
Lordship, I had already taken Lordship to these 3 voters list. Now we'll come to exhibit 5 and 6 voters list of 1993 and 2005, where my name of my wife and son are available.
Page,
That was,
voter list of,
I'm reading from page 64 last,
voter list of
93 and 2005, Lordship.
93 and 2005. Okay.
93 is the first time his name appeared, but
Yes,
with the wrong
yes,
spelling.
Page 43,
Yes, Lordship.
exhibit 5.
Exhibit 5 and 6 is 2005. 2005 onwards, if Lordship notices, the age discrepancies are not there. Everything seems to be in order. There is no mistake or anything with the name, age, father's name, village name, nothing, Lordship. No discrepancies at all. Then exhibit 6 and 5 and 6 we are done with. Exhibit 7 and 8, voters list of 2011 and 16. Names of my family members are available. Like I said, he has been very mindful. Now everything is in order there, including his daughter's name is also there in the voters list. Exhibit 10 is the license in his name, voter ID, my name and in the name of my son, Aadhaar cards in my name and in the name of my son, and affidavit sworn by me. This was the queries which we read at
Okay, Aizul is his
son.
son and the next proceeding in the other case.
Yes, Lordship.
Aizul's name comes first time in 2016.
Yes, Lordship will see in
Or is there any other?
2016.
2016, he is 29 years.
Yes, Lordship, I'll just come. Aizul is 29 years,
In 2016,
2016.
earlier voter list.
No, his name appears for the first time in 16.
But so far as Sulman is concerned, his name is there even in the 2011 voter list.
11, Lordship. There
He
is
was
only
26.
one sibling's name is, one child's name is there.
26. He was 26 years.
Yes,
And Azizul should have been in 2011.
his name could have figured 10 years prior to that, Lordship. 2011, Sulman Ali's name is there.
He should have been 20. He was 24 in 2011. He should have been there, Azizul.
And I think there's a typographical error or maybe a error because both the sons can't be 29. Serial number at page 48,
Yes.
serial number 530 and 531. If the Lordship looks at the age,
23, actually.
it's 23. So I thought it's 29. English version is 29.
Miss
23, no?
23. actually.
And Swahid Begum, I think, is the daughter. Here though they have 6 children, 4 children's name figure here. Everywhere in the depositions, they have said the
Now the
Gaudura
others
neighbor
may be less than the voters.
age.
They have not surpassed the reached this voters age.
By now, they
18.
must have it's
No,
24.
these are earlier voters.
Yes, Lordship.
The proceeding is of which year?
Proceeding is of, Lordship, this proceeding is of 19, but 16, the FT case was registered in the year 2016.
So this is acceptable.
And the reference is of 2010.
Till 16 or 17, he must have.
2010, if they had 6 children, now everybody would have been a major.
No, the defense was prepared in the year 2016. So 16, 17 up to
Yes,
17, they might have been less than
I know.
16 age, not reached 18.
Lordship will see the difference in all the voters list only after 2011, Lordship. That is prior to 1971. Now the voters list are in order. Before that, it's there are a lot of discrepancies in age here and there, and that may not be acceptable, Lordship. And the contradictions which have arisen here, they give a lot of doubt about the genuineness of the narrative which has been pleaded by the petitioner, Lordship. Now, Lordship, I would like to say the continuous stay is not there. Petitioner has not been able to prove his continuous stay in the state of Assam. And the documents which he is relying on the voters list, that has to be read as whole documents. And mentioning the name, Lordship, there is one citation which we had not referred, but I would like to refer to it today. That mentioning in Nam, mention for it. Yeah. Like he was referring to that in the notice, my father's name is Jahur Ali. And so he says, I have to prove my father to be Jahur Ali. Lordship, there is one thing I'll just read out. I'll share the citation. A notice issued by a foreigner's tribunal to a proceedee describing him or her as a son or daughter of some person and calling upon him or her to respond to a proceeding where his or her citizenship of India is questioned by the state cannot be construed as evidence of such relationship. It is neither evidence nor proof within the meaning of Section 3 of the Evidence Act. This is what my friend was referring to, that my father's name has been laid down as Jahur Ali. So I have to connect to Jahur Ali as my father. And Lordship, the citation, I will place it. It is WPC 3917 of 2016. And the name is Rupali Bibi.
The order dated?
Order dated 13/2/2018 by Justice Bhuiyan and
Rupali.
Rupali.
Justice Bhattakure, Justice Nelson is there.
Rupali?
Rupali Bibi.
Rupali, RUPALI BIBI.
That is not as per Section 3 of the Evidence Act.
Yes, Lordship. It is neither evidence nor proof within the meaning of Section 3 of the Evidence Act. So this is because being a fact in issue, it would have to be established as proof by giving evidence as per Sections 5 and 9.
Mr. Sikdar had put a lot of emphasis and based his arguments on the deposition of DW2 by contending that DW2's deposition has not been discussed or taken into consideration. What is your take on that?
Regarding the
DW2's deposition.
DW2 deposition.
He says that it has not been considered, no discussion.
Lordship, the records also do not, maybe the member did not think it necessary to discuss it.
No, isn't there any discussion? Is there a mention or not?
But Lordship,
No, is there a mention or not in the judgment?
I did go through it once.
You have not gone through the impugned opinion.
No, I had gone through it, but I was making other notes, Lordship. Lordship, what I would submit is that oral evidence is not enough in a
Has
proceeding.
it been what Mr. Sikdar has submitted? Is it correct?
There or something could have been taken into some discussion.
We are not getting the answer which we thought you would give. Come to page 75. Because we need to give a fair chance to Mr. Sikdar to rejoin. 75, the second last paragraph.
In support.
In support of the case of OP, there one of the neighbor, namely Samad Ali, is also present in the court and gave deposition DW2. And she is supporting the Indian nationality of his own and the OP therein. OP is cross-examined. See, Samad Ali's deposition we have checked. Samad Ali's deposition we have checked. He has not proved any document.
Yes.
So the settled law is that oral evidence without documentary proof, without contemporaneous record may not have much of a meaning. So what the tribunal has done is discuss the veracity of the documents.
Not supported by documents.
No, yes, he has considered the veracity of all the documents. Exhibits 1 to exhibit 15, I think.
Yes.
And when he has found that the documents are not reliable, then the oral evidence consideration may not come.
May not be taken.
We would like to have Mr. Sikdar also his views after you complete. We have seen this part.
My lord,
We'll complete.
But there is one linkage document. I have also forgotten to mention it. My friend also not. My friend referred.
Okay, after that,
My lord. Right there.
প্ৰুভ কৰিব লাগিব
ভুল হৈছে তো
এইটো কোনটো বস্তাৰ কোনটো চাই লওক
এইটো চাওক না 85 86
85 আপুনি আগৰ দেউতাৰ লগত আগত লিংকেজটো দেখুৱাওক
নহয় এইটোতো সি ৰিক্সা চলা মানুহ কৰা নাই নহয় এইটোতো মিউনিচিপাল বোর্ড কিন্তু পাবলিক ডকুমেন্টেশন অফ পাবলিক লাইসেন্স
but father লগত লিংকেজটো ফাৰ্ষ্ট
সে বাপের নাম নেই
নাম থাকিলে নহয়
কেন হবে ঠিক আছে
বাৰু 27 to 30 না 80
Yes, anything else? Ms.
Are
Verma?
you referring to the municipal board
my lord
paper?
driving license my lord
Driving license, it has been discussed.
page 52 my lord.
Driving license for cycle rickshaw.
My lord, rickshaw, my lord. Maybe whatever, but the issuing authority is a public authority, my lord.
See, there's a lot of difference between a driving license of a vehicle and of a cycle rickshaw. You know
My lord,
the rigors which is maintained.
it may be considered at least, my lord,
cannot
for
be-
linkage, my lord.
It cannot be at par. Driving license for a vehicle.
My
You
lord,
have to
at least,
go
my
by
lord,
the rigors. The cycle rickshaw,
my lord, at least, my lord, it indicates, my lord, that he was available in this part of land at that time, my lord. He has
That
not
also
having
will
total
help
list.
you. Just read very carefully.
driving license when has been held itself held not to be a proof of citizenship.
My lord, I am not saying that it is a proof of citizenship.
Linkage
But
you are
it
saying.
may be considered as a linkage, my lord. And it may be considered as that, considered that he was available in this part of land, my lord, at that time. Only for that consideration, my lord.
86, the driving license is of 86. And you vote yourself, you say your voters list, name had appeared in the voter list of 1993.
My lord.
Lordship,
Is this person and you the same?
Yes, my lord. With voter list, my lord, my
Page
father's
40
name is
page-
Zuhur Ali.
page
In the
40
driving license also, my father's
Page
name is
42,
my lord.
he is of 1993.
42. Yes, my lord.
What happened to the other earlier voters list?
42.
He has
My-
a driving license of 1986.
86. my lord.
Have you read
It was
carefully?
issued on 85, my lord.
there is a name.
It was issued
You
on
are
80.
in the 1985, you have 28 years. Which is your birth year? Which is your birth year?
My lord.
Work out,
That-
work out,
My lord, that
work out, work out. Can you tell
that
us?
may be a my lord, discrepancy.
Can you
my lord.
tell us?
28, 19. 1965.
What is the name of your father in that particular
Oh, Shah.
cycle rickshaw license?
Oh, the whole. Sorry.
Sorry.
यहाँ पर ठीक होता है अपने कोई नहीं ठीक होता है उनका स्टेटमेंट तो नीला रंग
And if you are relying or trying to rely on the cycle rickshaw license, you see what is your address given. If this is your license, first the name is Johu Ali, father's name. Then the address is Bhuyaputty.
Hujai.
Bhuyaputty Hujai, not Nilbanga.
Hujai. My lord, in the same, my lord, he was staying there.
No,
I think at that
every
time.
question's answer cannot be same,
My lord.
ignored. It's the same locality.
And if you consider this,
My lord,
then your birth year will be 1957 because you are 28 years in 1985.
85.
Whereas as per your voter list, your birth year was 1951.
sorry.
Nothing matches. Where in your written statement or in evidence you have stated that once you read in Bhuyaputty,
Well, nothing has been mentioned about the Bhuyaputty. That is there.
picking something from here and there, somewhere the name goes with you or your father. See, here is not even your father, it's somebody else.
No, my lord.
Look
My
at
lord,
look at the
my lord,
license. Look at the
Zohu
license.
Ali, yes, my
Zohu.
lord. Zohu Ali means,
Johur and Zohur Ali is the same. Where from you get it?
my lord, the people who written this one, well, they may have some mistake, my
That's
lord.
what my brother has
But
pointed out.
Zohur Ali and Zohu Ali, my lord, there is similarity, my lord.
And then how come you are Syed
Illiterate
Ali?
people, someone has written this way, my lord, what he can do, my lord.
What is your name? You are Syed Ali.
Syed
How
Ali.
come it happen to become Sahid Ali? This is Sahid Ali, son of Zahu Ali.
Lordship, after 2005, everything is correct, right up to the Epic, Lordship. The Aadhaar card, Epic, PAN, everything, if Lordship will look into that. But
Yeah.
prior to that, everything is out of place, Lordship.
In fact, from the records, of course, those are not before. The petitioner before the petitioner, the village defense secretary, the village headman, all said he started voting for the first time in the year 2005 while he is at village Nilbanga.
And his documents also before us, in this petition also, only after 2005 it is an order, Lordship. Prior to that, it is all a pick and choose method conveniently, whichever name is matches with them,
Which you have
it has
pointed
been
out is
taken up,
correct. The
Lordship.
one way it is correct because the name is, there was no mistake in the name. There was nothing
And the person passed away, father passed away, so
in the other.
Jahur Ali
It was
continues.
Sahad Ali. That is more important. Is Sahad Ali, son of late Zahur Ali. There is no, it is Syed Ali, son of Zahur Ali,
Basirun
which
Bibi
brother
ki
have already pointed out. House number differs,
has to be
the part
written.
differs.
My lord, for difference of house number, my lord, no negative view may be taken, my lord. In village, my lord, the house numbers are changing in every enumeration, my lord.
No, if in shifting it is changing, it is understood, Lordship.
House number changes in every enumeration.
No,
Yes,
Lordship.
my lord. Yes, my lord. Let the, my lord, election commissioner.
Why should they elect? We also have some
My lord.
practical
Yes, my lord, that
knowledge.
is my practical knowledge,
We
my
also
lord.
have some practical
We are village background, my lord. I know, my lord. These things changes in every year, every enumeration.
Even our roots are in the village.
It is not, my lord, my lord, our corporation or the municipal board, my lord.
Not necessary.
No, my lord, in village, my lord, every year enumeration, there has been changes.
Lordship, I would like to rely on 2-3 citations, Lordship. One is this, that the documents has to be read as a whole. The proposition is that I'm relying on Basirun Bibi, 2018, one GLT 372, paragraph 13, lot 30.
Full document, right?
Yes, documents has to be
2018?
read. 2018, 1 GLT 372, paragraph 30. Basiron, BB. It's a short paragraph. May I read it, Lordship?
Not required.
Not, and Lordship, the other one which I would like to rely on is and regarding the voters list, Lordship, it is WPC 7669
7669,
of 2016.
Hmm.
Boran Ali,
BURHAN.
yes, Lordship, decided on 8/6/2018. Paragraph 27.1.
What is the proposition?
Its voters list has to be relied on in its entirety, Lordship. And documentary evidence has to be proved on the basis of the contemporaneous record. This is another one which I would like to rely on. That is WPC 1073 of 2016. Muhammad Abdul Kudus.
They're disposed of.
Lordship disposed of on it's paragraph 15. I will find it out and give it. Paragraph 15, Abdul Kudus. लिखा न हो लेते था.
Oral evidence to be corroborated by contemporaneous records.
Documentary evidence has to be proved on the basis of contemporaneous records. And
That is documentary evidence.
yes,
We are talking about oral evidence.
oral also I'm giving oral. Lordship one.
Also give us about the hearsay evidence.
Yes, Lordship. Lordship, this is WPC, WPC 562 of 2016. Bijoy Das. Paragraph 17, Lordship.
Disposed of.
Disposed of on 18/4/2018.
This is regarding what?
This is regarding, it is tried that mere filing of written statement and oral testimony in a proceeding under the Foreigners Act 1946 would not be enough. The fact in issue would have to be proved by the proceedee by adducing documentary evidence which are admissible and relevant. The two documents filed by the petitioner were not proved in any matter whatsoever, and therefore the assertion of the petition that he, being a son of so-and-so, who was a citizen of India, was therefore a citizen of India, was not proved. Like here, the citizen, his linkage with his father is not proved, Lordship.
Yeah.
No idea. No good detail. It is Lordship, one more we would like to rely on, that is WPC 4512. Decided to take it
4512.
of 2016. Muhammad Fakhruddin.
Date of disposal.
Lordship one, date of disposal. This is, Lordship, I'm giving the date of disposal. This is regarding a discrepancy in age here and there may be acceptable, but consistent discrepancies in the date or year of birth coupled with other material omissions and contradictions would certainly raise grave doubts about the genuineness of the narrative presented by the petitioner. 28/2/2018 decided on, Lordship.
Four five one two public.
There is
Yes, Lordship.
the judgment oral evidence with contemporaneous document and there is a judgment.
Yes, Lordship, that is. That is, it will be decided on this one. Abdul Quddus, no? Abdul Quddus decided it was Abdul Quddus.
Abdul Quddus, you have cited 1073 of 16.
1073, Lordship.
Decided on.
No, 846. Lordship, this was decided on 7/5/2018. Itu dulu tuh ada sekolah itu contemporaneous. Ada 15 degree. Ini bisa banget ini. Nomina kapan tuh? Minta. This has been filled out. La política de la cultura.
My lord, I have to make a short submission, my lord. My lord, one point, my lord, about the oral evidence, consideration of the value of the my lord, oral evidence, my lord. The provisions of the Evidence Act says that oral evidence, even if documents are not produced, my lord, in to establish linkage, that should be considered. And in that connection, we have the judgment, my lord. In the case of Onil Sharma and others versus State of Jharkhand, it is reported as 2004 5 SCC 679.
2004 5 SCC.
2004 5 SCC 679. Paragraph 13 is the 11.
Name, whether it is applicable for the Foreigners Act.
My lord, it is for all, my lord.
is
Not
for
only
all.
foreigners, but it all. It's my lord.
How do you overcome 9?
Section
That's what we are
My
asking.
lord.
How do you overcome
My lord,
section?
Evidence Act is applicable.
No, section 9 is a special act. There are judgments after judgments from Fateh
Decided on.
to Muhammad Fateh to Ghaus Muhammad, then Sarbananda, Constitution bench,
My lord.
Ghaus Muhammad.
But my
Special act, section 9 is very clear, violence of section 9 upheld.
my lord, in our High Court also,
No,
there
that judgment.
there is judgment of the High Court also.
These are matters which have been settled long time back.
My lord, in our High
There
Court
is
also.
legal flaw in your judgment. Kindly do not again reopen something which has been settled.
My lord,
Section 9 you have to overcome.
my lord, in our
Make
High
some other arguments. We'll definitely.
My lord, in
consider-
our High Court judgment, my lord, in Hyderli case, my lord, Lordship may kindly have a look at, my lord, paragraph 42, subparagraph 4. There has been clear specific mention, my lord. Para 42, sub para 4 of
Decision
Hyder Ali case, my lord. Hyder Ali 2021 3 GLT 85, page 85. Para 42, 3 and 4, my lord, but now first time I'm reading, my lord, para 42, sub para Roman 4. Here, my lord, the statement is like that, my lord. Further, it is nowhere mandated that he must prove all these facts by documentary evidence only. Section 59 of the Evidence Act 1872 says that all facts except the contents of the document or electronic documents may be proved by oral evidence. There may be cases where the proceeding is illiterate and the birth is not registered with any authority, in which event it would be impossible to produce any documentary evidence to prove his date of birth, place of birth, and other facts accurately, and one may rely on the oral evidence only. In such case, can claim be thrown out merely because only oral evidence has been laid, my lord. So that is their claim, my lord. They want to throw everything because the only oral evidence, my lord. And para 3 also, sub para 3, one may prove one's citizenship.
42.3.
42.3, my lord. One may prove one's citizenship without referring accurately to all the factors mentioned under paragraph 26 of Sunwal 2 Supra. For example, if the date of birth or the place of birth is not conclusively proved, but if it is conclusively proved that father of the proceeding is an Indian citizen, the claim of the proceeding cannot be rejected as a foreigner, as it would lie in the face of logic and common sense. My lord, my father.
Mr. Singh, there is no dispute with this proposition. That is correct. Oral evidence can be, but can oral evidence in view of the major discrepancies,
My lord,
can it be accepted?
my submission is that here my oral evidence has been dejected and turned down without even appreciation, my lord. That is my submission, my lord. Let the tribunal decide it in proper way that if your oral evidence has no value, so I cannot accept the DW2 evidence. So you are friend. That is also not there. That is my submission. Whatever I have case, my lord, that has not been taken up for consideration, my lord. And my lord, there is a preliminary objection in the case, my lord, about the maintainability of the proceeding. The charge is also, my lord, back. There cannot be two charges.
You have perused the record? That is not a valid argument.
My lord, notice which I've got, that is indicated to.
No, that is not it. You have not seen the record. It is indicated which part. The notice is in a format. Which part you fall under, that has been indicated and stamped and typed. And stamped and signed.
My lord, while my other submission may be taken note. And my lord, in Hyder Ali's judgment also, referring to my lord, Sirajul Haq case, my lord.
Ms. Verma,
Paragraph
Yes,
43 may also be taken note.
kindly read it and show it to Mr. Singh. The SP's order.
It appears from the case record that there is a prima facie case against the suspected foreigner, Mohammed Saeed Ali, son of Yasir Ali,
That's the reference.
who entered into India on or after 25th March 1971 without valid documents. Hence, I refer the case to the coroner tribunal.
Proceeding has everything before him
Yes,
while
Lord.
he appeared before the tribunal.
And see the notice itself.
My lord,
This is the
there,
original
very
notice.
clear. You have also
There is
annexed
not
it.
only a tick, there is a
The
stamp.
notice which you have also.
No, the original notice. Can you, madam, show it to?
Notice is annexed to the petition.
No, that part is not very clear. Show the original notice.
Okay.
Please see, not only the tick, in the annexure, only the tick mark is there.
Seal is there.
Seal is there. The seal is there.
yes, my lord, there is tick mark, I admit, my lord. But here, my lord, the statement of the witnesses by the police The police is to take statement and
Okay.
submission and well, signature,
Lordship,
signature
this-
or thumb. That has not been taken, my lord.
these pleas have never been taken up in the WS, nor before the tribunal, Lordship.
My lord, these are the, my lord, legal
No,
questions, my lord, can
these
be
could
taken
have
up
been
anywhere,
taken up
anytime.
before the tribunal, Lordship.
See, normally, what we are doing in such cases, normally we see the what cases the reference has been forwarded. That's all. It has to be on the basis.
My lord, I will submit a written argument, my lord.
Mr.
I may be
Sikdar,
given.
Mr. Sikdar, since you had pointed out this, raised this point, we had checked the record. That's not that we just want to conclude that there is nothing.
My
wrong.
lord, my lord, I
We
appreciate,
checked,
my lord.
therefore,
I am obliged,
because whatever best is possible, we have to do.
my lord. My lord, I may be allowed to submit a written argument, my lord.
We have already noted it down. No,
My lord.
no need.
The challenge is with regard to the hearing is concluded, judgment is reserved.
Obliged, lord.
One to Jason, probability of all to. If we have to take that work is to. One, but. Okay. Okay.
Appellate authority
Notice
denied.
to sound, yes, sir.
The appellate authority denied. Phone call. I got the- So I am the under the appellate authority.
Notice my streamer report card. Streamer report.
It was recorded, it was a very good shape. Order to please. Right to order.
What is the order impugned, Mr. Bora, in your case?
My lord, no order is impugned. My prayer is then, my lord, because after the matter has been remanded back by this honorable court, my lord, nothing has happened. And since the year 2003, thereafter, during the process of NRC, the petitioner's name has not been included. So when he approached, then he.
Madam, what do you say in this matter? It's
Lordship,
a slightly technical issue now.
This was, the order was passed when the IMDC Act was in force.
and it was to be
By the
communicated.
tribunal.
Yes,
The petitioner never appeared before the tribunal.
never
He
appeared.
approached this court only when his name did not figure in the NRC.
NRC.
This order was passed
In 2003, Lordship.
2003 and we're hearing the counsel for the petitioner.
एक second. No, no, itu no itu. हो जाए. Discuss हो तो. Lordship will take up this matter day after we will. We have instructions, it seems, on this one.
Because we need to apply our mind here.
Yes, Lordship.
Because there was a remand order, though there was, the earlier orders were set aside. The matters were remanded for a decision afresh.
Afresh,
In the
Lordship.
meantime, IMDT goes. And until there is a reference by, under the present
Still pending.
system,
Yes,
it cannot be reopened. But the issue of being a foreigner or an Indian citizen has to be adjudicated.
he has to appear and submit his documents, prove his citizenship.
But aren't you aware that there is an order of the Honorable Supreme Court
Yes,
that
Lordship.
all matters
Shifted.
are transferred?
Transfer to
So
freshly
as per that
appointed,
order, we can have it.
all shift transferred
Yes, my
to
lord,
newly.
that is my prayer, my lord. My prayer is to take up the matter for.
That's it. We'll pass the order.
My prayer is also
Will
that.
they have
So
to
they have
do-
to vote.
Yes, my lord.
You try to have a.
Those two
get
orders,
hold of the-
after the apex court order, is a particular direction of the government. Referring with all these matters.
Matters to the tribunal.
Fine, I tell you.
That particular order, there are three orders. Those which are pending for consideration. And need not be
References
reopened, which are already been decided,
decided.
right?
And
then
fresh
those who are
references.
pending for waiting and the verdicts are awaited. And there is another issue. There are three particular matters which are considered to be considered by afresh by the tribunals.
By the
giving
tribunals.
notice to the,
Proceed.
get that notification of the
And
government.
here, in fact, since he is before us, the our notice part can be dispensed with.
Yes.
Yes.
We can fix a date.
But
And-
the tribunal is, that is, matter was referred back to the appellate authority against the order of the tribunal.
Tribunal.
But there is now no appellate authority under the Foreign Affairs
Yes,
Act.
Lordship.
And that act has already been, so that means set aside first, that is the reason we have to send it back to the tribe,
Tribunal.
but we need that notification. It may be available in the book of
Sabanata.
post of Gogoi.
Yes.
There's the certain notifications are there. Find out that book notice will be available.
I'll do that. Seven and the will do to clarification.
Mr. Sharma, Ms. Sharma, find out that notification we need. There is a specific notification after the judgment of Sarvananda Sonowal 1.
I
Amla-
think in two it's clarified. Isn't it? Lordship fixed for Wednesday.
Yes. Yeah. The two currently.
28 है itu monot ko ba? Ase tumati pa. Item. Lordship 2 was adjourned in the morning for 5-3. Lordship had adjourned item 2. And next date was given as 5-3-24, Lordship.
This is 22.
22. Shukur Ali.
Lordship, my senior is coming. Lordship.
Lordship, other matters, Lordship had left to pass orders in the second half. 11, 12, 13, Lordship. 11 and 13.
There are continuous defaults in this matter.
The
given
default
that-
matters are different, Lordship. That is item 8. None has appeared.
22 liter.
What I say, I think 8 this will do. 26, 27 also.
22. 22 will have day after tomorrow. We'll seek a further clarification from the registry.
Lordship.
Lordship, item 8 and 26, 27, Lordship said would pass orders at 2. And none has appeared in this matter for the last 3-4 dates, Lordship. No, item 8. 8. If I put them, 8 to there. Manju Dev. Follow that. I'll follow.
The matter is taken up for consideration the first. Petitioner remain active. Given an earlier two occasions, 9/2/2020, 05/01/2020. आगे कोई दिवा 05/02/2020 and petitioner remain active. Order to give order.
8. Tomorrow.
We had also observed the footage been fixed to the last occurrence.
By order dated 4/11/2011, my lord, the petitioner has been declared to be a foreigner, my lord. And 1966 to 71 is still, my lord. And she was directed to get her name registered, my lord, within a period of 2 months, my lord, but she could not register his name, my lord, her name, my lord, within the stipulated period, my lord. So, my lord, my humble submission before your lordship, my lord, a last chance may be given to her, my lord. She will register her, get her name registered, my lord.
Lordship 2011 order,
Yes,
Lordship. And it's 24 now, 15 years.
yes, my lord. In fact, no, she approached her, but they denied her.
But when did she approach, Lordship? There
Kindly
is a
see
time.
paragraph number 9 of my petition, my lord.
You had made wrong statements in the AFS. You had to have the
Yes. Last chance may be given, my lord. She will get her name registered, my lord.
we are also
The
we
time
have
period
to
may be
take the
given, my
version
lord.
of the bar association. Thereafter, and this matter is pending since 17th.
Yes. I have specifically.
Today also you are not appearing when it was first half, it was not there, you are not there.
Matter of 2017, the petitioner never pursued the matter also, Lordship. Today, pleading for urgency does not seem to be in place, Lordship.
Okay.
Day after tomorrow.
27 to first order only.
8.
27, huh? First order only. Last two. Then the fellow. Dismissal not. Even if we've taken up in the past. It's not good. It's not first order. Right.
Okay, লিখি দিয়েছেন তো 28
Later here. I think এখন আমাকে একটু মোটাতে দিতে হবে মই ওটা to name of the two conditions have been reflected in the corpus. The interim order, certainly. This petition is against. But interim order passed earlier. 22/12/2017. Thereby recall of extends packet. Register seal inform the superintendent of police board.
Yes, okay.
Communicate this order.
At 47, we got the instructions.
So, right.
Lordship, item 47, Lordship has asked us to get instruction supply. The petitioner has already registered, Lordship.
We'll take it up tomorrow.
Yes, Lordship.
By slip tomorrow. But you gave us that,
Instruction.
tomorrow, when the matter is.
I beg to mention, my lord, item number 15, my lord. That matter may be taken up, my lord, next week.
You need to come next.
But
Bipul, item 803 order delay. Item 803 order delay. Wait. Manju did. Just minute, na? Oh, yes, sir.